Hi everyone, we're about to get started again. If you can just take your seat and quiet down. I hope you enjoyed lunch.
In Detroit, an emotional reunion for a young man who was released from prison after serving 9 years for murders he did not commit. Devontae Sanford walked out a free man and went home to his mother and his family. He was convicted when he was just 15 years old, even though authorities say the real murderer confessed long ago. ABC's Alex Perez is in Detroit.
The embrace Devontae Sanford thought he might never get. Hugging his mom as a free man for the first time in nearly 9 years.
What was the hardest part when you're behind bars and you're so young?
Knowing I'm in there for something I didn't do.
23-year-old Sanford walked out of this Detroit area prison Wednesday, charged when he was just 14 of murdering 4 people. Sanford, who is blind in one eye, was picked up by police near the scene of the crime. His attorney saying he was coerced at the time into falsely confessing after 2 days of interrogation.
Devontae talks about the police officers who befriended him and then coerced him into a confession.
A convicted hitman who's already in jail admitted to the murders just weeks after Sanford's conviction. The prosecutor tonight defending the handling of the case.
I can't be a Monday morning quarterback. We had a good reason to charge.
Sanford saying he's not bitter.
I was angry when I was in, but I'm home now, so I'm not angry anymore.
And David, Devontae's first meal as a free man, Chinese food. He says he's now looking forward to getting his driver's license. David?
So Devontae, I just want to thank you for coming out today, and Miss Newman as well. Thank you so much for being here with us. As a young person who also grew up in Detroit, Michigan, we're really close in age. Your story just really struck a chord with me and really made me want to make sure on a national level everyone found out about it. Everyone in this community, many of my colleagues knew about your story. So thank you again for coming here. So like so many of our clients who we work with, we recognize that before they're ever accused of a crime, they are children first. They have a childhood, they have experiences, they have activities that they like to do, there are things that they're interested in. So before this whole case unfolded, when you were just 14, can you take us back and talk about, the activities you like to do, the things that you were interested in at that age?
It wasn't much to be interested in doing in my neighborhood. I mean, I grew up kind of rough, no father figure. My mother, she was going through different struggles and addictions, she was battling. So, school wasn't, it wasn't teaching us anything. So I was lost. I was very unconscious of the world, what was going on around me, right? And it became real once I found myself charged with 4 counts of murder.
So can you actually go in further? How does a 14-year-old even get implicated in something like this? How were you identified and arrested?
My mother came home one night. I had just left my auntie's house. My mother came home because she had just went to the gas station. And she came home, and she was like, something just happened, the police everywhere. Stay in the house. I didn't listen. I called this girl. I said, look, I'm about to come over your house. Is you gonna sneak me in the back door? She was like, yeah. And I had my pajamas on. I had my pajamas on with a hoodie. I left and snuck out the house. As I was walking down the street, I noticed a K-9 unit and 3 police officers canvassing the neighborhood, knocking on the door. So as I was walking up the block, we basically met up. They stopped me, asked me who I was, where I lived, my age, have I seen anything, know anything. I told them no. Multiple occasions, no, I haven't seen anything, I don't know nothing. And I told one of the officers that I knew a police officer, I was just with a police officer. And they said, well, who is he? And I told him. I said, well, his name is Bill Rice. And he was like, oh, I know Bill, he used to work homicide. He called him. He was like, Bill told him, yeah, he was just with me, and I just dropped him off for school. And that it went from there to them basically taking me back home, talking to my grandmother, telling my grandmother they want to ask me a couple questions. My grandmother signed the waiver, so they will be able to question me. Then next thing you know, I was right where the murders occurred, being tested for gunshot residue. From there, they took me to Coney Island, got me something to eat, let me be on the computer, like just all type of things like that. And they kept me like that night. They woke me up in the morning around 8 or 9 o'clock. And they was like, look, just sign this statement real quick so you can go ahead and go on about your business. I signed the statement. At the time, like, I barely knew how to read. I barely knew how to write. They were just like initial. So like, that's what I did. They wind up taking me to the prosecutor office that same day. And from my understanding, the prosecutor didn't want to give me a letter check this because I was too young. From there, I went home. And when I got home later on that night, around 9 o'clock, the detectives came back to my house, and they got to like talking to my mother, trying to convince my mother like I knew something, I had to know something, had to been there. And I even told my mother, I don't know nothing, you know. And I started crying, and my mother was like, if you know something, tell them. Like, I don't. And they convinced my mother, like, we just want to talk to him one more time. We're going to bring him back home. And my mother was like, because he got to be in school. He got to go register in school tomorrow. So I went down there, and I knew this time it was going to be different once they put me in the back of the car. And we got on the freeway. And they were just, like, talking to me, like, asking me what I've been doing that day, different things like that. It went from that to them telling me, like, look, we got a problem. I said, what? And they said, we think you've been lying to us. I said, no, I haven't. I don't know nothing. And they say, well, we just want to let you know that we did some tests on your shoes, and it came back. You had blood on your shoes. I panicked. I was scared, like blood. Like, how did blood get on my shoes? Like, I don't know how blood would get on my shoes. So I lied. I said, my dog had got into a fight. I went outside to break the fight up. That's how the blood got on my shoes. And they said, no, that's not dog blood. We tested it. That's human blood. Like, be honest with us. And I'm like, look, I don't know. I don't know. They said, well, you got some explaining to do. It was blood found on your shoes. And they took me down to the station. And that's when they got the question. That's when they, like, started showing me pictures of the victims. Like, started showing me pictures of the crime scene. And they was like, look, tell us where the bodies was at. And one of the detectives, he drew a map and was like, just show us where the bodies was at. This all we want to know. Just show us where the bodies was at. I did it. And they was like, sign it. I signed it. And once I signed it, the detective was like, bingo, I told y'all.
Interesting. And that's very, it's heartbreaking to hear that, you know, officers that seemingly befriended you and were buying you food and things like that kind of, well, really did coerce you. They coerced you into identifying things that you really had no knowledge of. And so turning to you, Valerie, can you elaborate really on the ways that Devontae's adolescence affected his ability to understand the decisions he was making, the confession, or even, you know, pleading guilty? Can you talk about how adolescence affected?
Sure. I mean, we've already heard a lot today from much more well-informed speakers than I am about what happens with adolescents when they encounter the police. And I think the biggest factor here, I think there were two factors that were huge. One is the predatory conduct, befriending him when they first it was, you know, Devontae saying, I don't know what happened. I've been in the house. I was at my auntie's house. I just came home, and I just came outside. I have no clue what happened. And them saying, you know, we don't believe you right off the bat. You know something. You're out on the street. You know, you're a young kid out on the street on a school night. Like this assumption that he had to have some sort of information. And then turning to this conduct, you know, calling him a liar when he said he had just come from from being with a police officer, and they called Bill Rice. Bill Rice, you should understand, was one of the head detectives in the homicide department. This is not some low-ranking police officer, and it's basically his uncle. And so there's so many components to this story that are tragic. I mean, every single step along the way. So his own uncle tells one of these detectives, Detective Collins, look, he didn't do anything. He was with me. I'm telling you, he couldn't have been involved in the crime, but he's a streetwise kid. He might know something, so it's worth talking to him. So his own uncle starts this process in motion with the police, I guess, thinking that he was protected because his uncle was Bill Rice. Instead, you know, basically throwing him to the wolves to set things up. And so when he goes down, so now that they know Bill Rice is his uncle, and now they turn to the befriending. And it's taking and buying him whatever he wants. You're hungry? Let's go to the Coney. Order anything you want. You want a cheeseburger? You want fries? Whatever it is, we'll buy it for you. Taking him to the station, letting him play on the computer. A little bit of questioning. Basically keeping him there for hours, though. I mean, right? You fell asleep on a hard bench until they decided to wake him up and take him home. So everything they said they would do, they did. You talk to us. No problem, we'll take you home. So it completely set the stage, right, for what we all know is coming, which is the second stage of interrogations. So now he trusts them. They say, you talk to us, you sign this, we'll take you home. That's what he expects is going to happen because, like we've heard, children are very compliant. They want to please the adults that are around them. And now these adults have made good on everything that they said that they would do. So when they come back and they talk to his mother is thinking, again, he's protected by this very high-ranking homicide detective that's a relative. So, you know, nothing's going to happen to him. And if he knows more, she's encouraging him, right, to share it. Like, if you know something, tell them. This was a horrible quadruple homicide that occurred right around the corner from their house. And so he goes back, and they feed him the same stuff. Just cooperate, just talk to us. You know, the good cop, bad cop, you're a liar, we've got the blood, you know, we've got this. Now, what Devontae didn't mention is that when they tested him for gunshot residue on his hands, then, like, within an hour of the shooting, that test came up negative. So there's no way. He would have had to scrub his hands with bleach to not have a speck of gunshot residue anywhere on him. And so they already sort of knew that he couldn't have shot a gun or been near anyone who shot a gun. But they persisted because I think what happened in this case is he just became an easy target. We had a quadruple homicide. Here's a kid. Let's just pin it on him and we'll be done. The case was closed within 24 hours of the shooting because they pinned everything on Devontae with really no evidence other than his confession, which they knew they needed. And there's more about the confession, but I don't want to keep that he didn't talk about, but I don't know how much you want me to talk.
So what I did want to kind of draw it a little bit more is you mentioned that they targeted Devontae. They were fine with pinning this on Devontae and really charging him as an adult for this crime. And we heard from various presenters, Devin Carbado and others, who talked about the adultification research that showed that African-American youth are perceived due to racial bias as older, more culpable. So can both of you kind of talk about the ways that race may have played a role in any aspect of this case?
You want to start?
It played a big role. My attorney at the time, Robert Slamaker, I told him I wanted a jury trial. And he looked at me and said, "You a poor black kid from the ghetto. These white people about to come in from the suburbs, they finding you guilty." He said, you out of your, excuse my language, but you'll be out your rabbit ass mind if you take a jury trial. I was forced into taking a bench trial. Something I didn't even want to do. You know, so like, of course, like it played a big role. I'm like, okay, this is my attorney, he got to know what he's talking about. You know, he said, look, if you take a jury trial, these white people gonna come in here and find you guilty.
That's crazy.
Well, and I think race played such a pervasive role that it's hard to detail all the ways in which I think race played a role. I mean, first of all, who in their right mind thinks a 14-year-old kid in his pajama bottoms just committed a quadruple homicide at a drug house? It's insane, right? I mean, everyone in this room, I think, would agree that's crazy. I mean, this is the kid that just has stealthily murdered 4 people, shot a 5th who survived, walked out of the house with cash, money, cash and money, that's the same thing, right? Drugs, money, and some weapons, and stashed it at home, and then casually is just going to walk out on the street as if absolutely nothing happened. Oh, that's right. And had a shootout with the neighbor. Let's not forget the shootout with the neighbor. So who happened to be a police chaplain and just happened to have a high-powered rifle in his home so he could engage in a shootout in case he needed it. So you had, if the police had even moderately tried to do their job, you had an independent, very reliable, I think by anybody's standards, witness in this police chaplain who lived in the house, who witnessed the entire crime, who told the police that there were 2 adult black males dressed completely in black who were tall, thin. They were both tall and thin. So Devontae's taller now than he was then. He was 5'5" and like 155 pounds. In no one's universe, except maybe mine, because I'm short, is that tall, right? But that's not tall and thin. And the police chaplain said tall meaning over 6 foot. And the other guy was a little bit shorter, like maybe 5'11". So you have, someone who's arguably maybe trained to pay attention to those kinds of details. And he engaged in a shootout with them. And they had shells right from the shootout. So at a bare minimum, good law enforcement work, you'd be looking for 2 tall, thin, adult males, suspects. And they found no weapons in his house. Where are the weapons? They found a few shells, right? They found some black clothing. Wow, that's a shocker. A young man who has black clothing in his closet. None of us would expect that. And so, I mean, it's just, in what universe would you expect this 14-year-old kid, I think only under these circumstances, and because he's black, would anyone say that he could be capable of committing the crime? And then it was just a snowball, that anyone would believe the confession, that his attorney came into this thinking he's guilty and did nothing. Nothing. He never interviewed a witness, never filed a pretrial motion, never talked to Devontae to get the facts of what. He never challenged the confession. I mean, he literally did nothing because he assumed he was guilty, and he assumed that he would eventually convince Devontae and his mother that it was in his best interest to plead guilty, which he did. Which he did.
And that was actually going to be my next question, was about zealous advocacy, because there seem to be multiple places in this case where better client counseling, or any client counseling, zealous advocacy could have really shifted the outcome of this case. So Devontae first, do you remember things that you didn't understand that were happening around you that you wish your attorney would have explained? Or do you remember there was one thing that you wish someone would have broken down for you so you understood exactly what was happening?
Everything. I mean, like a whole lot. Even my plea deal. When the witness, she was a victim. She was shot maybe like 6, 7 times. She survived. And they made me get up during trial and say and repeat what the robber said. I repeated. And she instantly said, "That's him." And they said, "Well, how you know it's him?" His voice, right? And I looked at my lawyer, and my lawyer looked at me. He just gave me this look like, it's over with, like you. And I said, I looked at him and I told him, like, look, I want to take a plea. And even before I told him I wanted to take a plea, he was like, you might get like 15, 20 years. Like, okay, he was like, it'd be easier for you to come back off a plea. And like, if you get life in prison, you would never be able to file appeals, and telling me all these different things. So when it was time for me to like take the plea, he literally just went and got the plea papers and a piece and a pen, came over and gave it to me and walked away from the table. And like he came back and was like, "You signed it?" I was like, "Yeah." And he took it over to the prosecutor. I think if I would have understood like what I was taking and what I was signing, I don't think I would have ever did it. I mean, like, they offered me like 22 and a half years. The judge over-sentenced me. He gave me 39 to 90 years.
Wow.
So it's like, wow, only if I knew like what I was signing, I don't think I would have signed it, but it was hard. It was hard.
Understandably. It's unbelievable almost that this even happened to you. And so, Ms. Newman, I also want to give you a chance to answer that question about zealous advocacy. Do you think that there are other places throughout the case that zealous advocacy could have truly shifted the outcome?
Yeah, there's no question, right? I mean, I don't think there's an attorney in this room, whether you're on the defense or the prosecution, who would say that this case was handled appropriately in any way, shape, or form, from the law enforcement investigation to the prosecution to the defense.
Murder weapons. It wasn't even the right murder weapons.
To the appeal, to anything that happened in this case, really. So we should backtrack for just a second so people really understand how egregious this is, which is Devontae's confession was that he and 3 other people committed this crime and that there were 4 weapons involved in the crime. Physical evidence said there were 2 weapons involved in the crime. The other 3 people he initially implicated all had alibis that checked out, never charged. There were so many red flags that this was a false confession at every single stage of the proceedings. He was sent for a forensic examination. In Michigan, you can, I'm assuming in most states, you can get a forensic examination to determine competency to stand trial and competency to waive Miranda rights. And geez, you would have a field day, right? Most of us challenging this confession. You'd have a 3-day hearing challenging this confession, bringing in experts on false confessions, bringing in experts on juveniles. I mean, you'd rip this thing to shreds because there is nothing in his confession that matches the facts of the crime. I mean, virtually nothing other than the fact that people were killed and shot. I mean, the facts that were made, that the police knew, are the accurate facts. And so I think that, you know, it's sort of an institutional racism that just built on itself like a snowball that became impossible to stop. And you see that if anyone watched Kim Worthy's press conference when they announced that they were going to actually agree to vacate the charges and dismiss the entire case, it was a horrible press conference. She attacked everybody but her office. Her office did nothing wrong. And she's the first female, black and female, independently, prosecutor in Wayne County. So this woman is an icon in many, many respects. But she stood up there and defended everything that happened in this case, despite the fact that her prosecutors knew 2 weeks after Devontae was sent to prison that a contractual hitman confessed to the murders. Not only did he confess, his confession matched the facts perfectly. Down to what he did to prepare. He said he'd never heard of Devontae Sanford. He didn't know who he was, and he was a professional. There's no way he'd use a 14-year-old kid as a sidekick. He did have a sidekick who he wouldn't name, but it was not Devontae. So not only did he disavow that Devontae had any involvement, admitted his own involvement, but he also had all the facts correct, including a critical fact, which is which he couldn't manufacture. There was a handgun stolen from that crime scene on Runyon Street. That handgun was used to murder a police officer's wife. A hit that Vincent Smothers committed. Where did he get the gun if he didn't steal it when he committed the Runyon Street? So there were, I mean, just
Lots of
so many things that connected him independently to the fact that he committed this crime, down to the fact that the prosecutor told Vincent, the plea deal that was offered to Vincent Smothers was contingent on him. First of all, he didn't have to plead to the Runyon. He was never charged with the Runyon Street murders ever. And his plea deal for 12 murders was, I think, almost less time than Devontae was serving for his alleged 4 murders, and conditioned upon the fact that he would not talk about the Runyon Street murders. So you want to talk about pervasive misconduct, institutional racism, everything else that's going on to protect the police officers that coerce his confession. This is like, this is truth is stranger than fiction, right? You could not make this up. No one would believe you.
Right.
If this was in a book. You would read this and say this could never happen. But yet.
And so in talking about the typical exoneration process, why is it that Devontae remained incarcerated for another 8 years after a person comes forward and says, I did this, all the evidence matches up, you know? How did that even happen, is I guess my question for you in terms of the typical exoneration process?
Prosecutor's office. They had every incentive. They had already decided, obviously, early on when they offered Vincent Smothers the plea deal, that it was more important to protect the misconduct and the officers who were involved than it was to do justice. And so I believe Devontae would still be in prison right now if it was just the lawyers litigating the case. I do. The thing that, the motivating factor that broke this case was the involvement of the Michigan State Police. And the Michigan State Police got involved because they were initially asked to be involved when Bill Rice testified at one of the hearings on Devontae's behalf, and it was believed that he lied on the stand, which he did. He got on, whether he lied or made a mistake, the prosecutors called it perjury and prosecuted him for it. When he testified that he dropped Devontae off at home and the rest of his family after the time that the shooting had occurred, when in fact he had dropped them off before the shooting had occurred. And so they had no problem going after Bill Rice, none. But they wouldn't go after any of the officers that had framed him and coerced his confession and put him in prison. But once the Michigan State Police were again asked to come forward after we filed in Michigan what's a post-conviction motion for relief from judgment, and they were impeccable. They did an unbelievable investigation. They left no stone unturned. They investigated for a year. They requested charges against some of the officers involved, which were declined. The prosecutor did not charge any of the officers that were involved. They're all still working, other than Tolbert, who was the main guy who drew the diagram and showed, had Devontae put where the pictures are. He went on to be the police chief in Flint, and then he got fired, and I don't know what he's doing now. But he was never prosecuted, and the statute of limitations has passed. So, talk about something that could take a day. We could take an entire conference dissecting everything that went wrong in this case and trying to figure out why and how to make sure it never happens again.
Well, Devontae, recently through the mini-series about Kalief Browder, we've been reminded about the difficulties experienced by children who are prosecuted in the adult system, who go into adult facilities at such a young age. For those of you who may not be familiar, Kalief Browder was only 16 years old when he was accused of stealing a backpack and ultimately held for 3 years at Rikers. And so first I want to say you are very brave and courageous as you sit before me on this stage. And I just wanted to ask, how did you persevere through this experience? What sustained you while you were, incarcerated?
My mother. My mother. She never gave up. I mean, she used to be in the snow, in the rain, holding signs saying, "Free my baby." Like, my mother, fought so hard. So, when I didn't have, the energy and I felt like giving up, I used to feed off all the energy she gave me. I had people from all over the world I never knew, never met, flying in just to come to my court dates, writing me, calling, talking to me on the phone. It was, my mother did that, you know. Yeah, my mother. I went through hell. I mean, I done been through like so much. A lot of people don't know, like, prison is a total like different world, you know. It was times where like they strapped me down to the bed, hours, days at a time, you know. I did, what, 11 months solitary confinement, you know, a whole month, no shower, because they don't want to let me take a shower, rip mail up, spit in my food. Like, I done been through all type of things. But my mother is what, like, kept me fighting. She kept me fighting. Like, I went like 5 years without no type of contact visits whatsoever. I wasn't even able to, like, to see my family. You know, it was hard. It was hard. It was rough, but it made me who I am today. It made me, like, I'm stronger than ever now, though. You know, so
And speaking about that, you know, you've been very resilient since you've been released, you know, hitting the ground running. You're working on a nonprofit, Innocent Dreams. Can you tell us a little bit about what you hope to achieve through that organization?
I just found out, was it yesterday, I received my tax exempt status. I was happy about that. But, like, yeah, I hurt so much. Every time I turn the news on or I go on social media and I see young black men, you know, being murdered in the street or being sent to prison for senseless crimes. Like, it, because I done been through that. I know what it's like. I've been through it, and I did time for somebody else's crimes, right? And it was hell for me. So I can just imagine what it's gonna be like for them. I can just imagine what it's gonna be like for their mother, their brother, their sisters. I didn't live through that. So I don't want people going through that when they don't have to. You know, I don't want to see people going through that when they don't have to. So I'm like, when I get out of prison, I'm gonna try my best to share my story as much as possible. Whoever listens, hopefully they can take something away from it and learn from everything I done been through so they don't have to go through it. So I launched my nonprofit. I go around, I speak at high schools, and I speak at different events where mentoring youth. And I talk to them about my case. I talk to them about violence prevention, gang prevention. I speak on, we speak about like law, and I always, in like any one of my speeches or one of my talks, will like asking who in the room like know their Miranda rights. You know, because like that was another thing that got me, my Miranda rights. And I talk to them about like, what is your Miranda rights? And like, I tell them how important it is to know your Miranda rights. You know, because if you ever find yourself in a situation, that's all you got. So, yeah.
Thank you for sharing that, and best of luck with Innocent Dreams. I know it's going to be a fantastic organization. I look forward to hearing more. Before we go to the audience for questions, as a final question for you, you have all these stakeholders in the room, people who are committed to ensuring that this does not happen to anyone else. You are the reason why we have this symposium, why the right to remain children is so critical. What is one thing that you would like to leave everyone in this room with?
Imagine if I was your son, your brother, your nephew. Don't just look at me and just think, okay. No, it's deeper than that. It's deeper than that. If them detectives would have been looking at me as if I was their son, just like they promised me they was gonna take me home that night, I would have went home that night, period. They didn't look at me like that.
That's very important. And I think that really is what the right to remain children means. You know, think of this. What if this was your child? You know. So we'll go to the audience now if anyone has a question for Devontae or Valerie.
Being that you referred to the case with a gentleman in New York, he eventually committed suicide because of
It's hard. It's very, 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 very hard. You know, when I think that case in New York, him committing suicide, like I felt like crying. That was me once upon a time, sitting in my cell contemplating suicide, thinking like I would never get out of prison, right? Hearing that every day, thinking like I'd never been to prom, homecoming, none of that. This is about to be my life for 39 years, you know? It was hard. I still deal with it to this day. I was out for maybe, what, 5 months before he was murdered?
Roughly.
Yeah, like my stepfather. When I got out of prison, he was murdered. And I wanted to cry, I wanted to scream like everybody else. He was laying in the street for like 4 hours, just out there. I couldn't. Prison snatched that away from me. It snatched away the emotion and compassion and being able like to really feel and express your feelings. So I'm just now getting back into that. You know, I'm taking one day, one step at a time. I talk to a therapist, and I'm just, you know, I'm not rushing nothing. You know, I'm just taking my time with it.
Okay. And I think quickly we have time for one more very quick question.
Okay. I hope it's quick. Mr. Sanford, I just want to know, has anyone apologized to you for what you've been through? Because I'm listening to this and I'm shaking with rage, and I just keep thinking that I owe you an apology because this is our government that did this to you. I don't live in Michigan, but this is my country too. And I'm sorry, and I just wanted to know if anyone has apologized to you.
No, I haven't received like no type of apology, no type of sorry, nothing. It was just, they let me out of prison, and when they let me out, they gave me a $15 check. It was like going about your business, basically.
That's crazy.
Yeah. They let me out. It was like, gave me an envelope, and we was in the car, we opened it, it was what?
Yeah.
$15. I haven't received a telephone call, anything, nothing.
Well, I'm sure after this you'll be getting a bunch. So thank you so much to both of you for joining us.
I gotta say, I'm not sure there are any words I could possibly say after that. I will just simply say thank you, Devontae, for sharing your story. Thank you for your resilience, and thank you for inspiring the rest of us. I hope to work harder than ever to make sure this doesn't happen to anybody else. So thank you. We appreciate you. Thank you, sweetie. So we spend a lot of time when we talk about policing and race. We spend a lot of time talking about boys, but it is absolutely essential that we don't neglect our girls. Children of color, girls included, are often treated differently. And so our next panel will explore that question. So I will invite. Actually, it's a fireside chat. I will invite all of our chat participants to join us, and it will be moderated by Maheen Kaleem. Thank you so much.
Well, we have a very tough act to follow, but good afternoon, everyone. My name is Maheen Kaleem. I'm with Rights for Girls. I know that we haven't done introductions throughout the day, but because not everyone can see everyone's name cards, I'm going to ask my panelists to introduce themselves very quickly. So, like I said, my name is Maheen Kaleem. I'm a staff attorney with an organization called Rights for Girls that's based here in Washington, D.C.
My name is Jyoti Nanda. I'm at UCLA, and I founded a clinic 4 years ago called the Youth and Justice Clinic.
My name is Jamelia Blake, and I'm an associate professor at Texas A&M University, and I do research on the disparate impact of school discipline for Black females.
And I'm Rebecca Epstein, and I'm the executive director of the Center on Poverty and Inequality here at Georgetown Law.
Thank you. So I think Valerie and Aaron and Devontae really centered us and brought us home in a lot of ways in terms of really thinking about who we're talking about when we have these conversations. And one of my favorite scholar activists, Dr. Monique Morris, will always warn us that before girls in the juvenile justice system are victims of oppression and trauma and multiple forms of interpersonal and state violence, they are girls. They are funny, they are smart, they like music, they don't like their peers sometimes, they are creative, they are in love, they are eager to learn information. They have dreams and they have goals. So in order for us to have a really fruitful conversation, I want us all to take a second to think, and because today's conversation doesn't just center on girls, it centers on girls of color, I want you each to take a moment to think about one particular girl of color. Think about what she likes, what she doesn't like, what your relationship is to her, what's important to her, and keep her in mind as we move through our discussion today. So although nationally many people in this room have been part of a heroic effort to reduce the number of justice-involved youth around the country, our failure to contemplate and address the needs specifically of justice-involved girls has left us with a predicament. While the number of justice-involved youth nationally has decreased, we have seen disproportionate increases in the rates of girls' involvement in the juvenile justice system at every single point of contact. Perhaps more disturbing, existing data demonstrates that girls are being funneled into the juvenile justice system as the result of criminalization of their abuse, something our organization likes to call the abuse to prison pipeline, where they are criminalized for their trauma. This is especially true for girls of color. African American girls constitute 14% of the general population nationally, but they are 33.2% of girls detained and committed. Native American girls are 1% of the population generally, and 3.5% of youth in the juvenile justice system. Between 1997 and 2013, the share of Latina girls in residential placement went from 12% to 20.3%. And here in the District of Columbia, the share of girls in the juvenile justice system has increased threefold over the past decade. And almost 100% of the girls that touch Washington, D.C.'s juvenile justice system are girls of color. So today, we're going to hear from our esteemed panel about why girls are being funneled into the juvenile justice system and how that may be unique from boys, what makes them vulnerable to justice involvement, and how we can stem this increase. So I'm going to start with Dr. Blake and Rebecca. I think before we even get into the piece about justice involvement, it's really important to talk about perceptions of girls of color and the social context that renders them vulnerable to multiple systems of oppression. So I know that Dr. Blake and Rebecca, you are in the process of publishing a report entitled Girlhood Interrupted: Eradicating Black Girlhood. So if you could tell us a little bit about your report, what you found, and what implications or takeaways that you find relevant to our discussion today.
Absolutely. Thank you so much. So when we talk about what kind of influences girls, particularly Black girls, to have a disparate impact of juvenile justice system, similar to Goff, there have been conversations about girls being adultified or experiencing adultification. And what Rebecca and I noticed is as we reviewed the literature, a lot of the emphasis continued to be on Black males and not really talking about Black girls. And so the stereotype that kind of guides this conversation is, well, Black males are more threatening, right? So not only are they not only considered childlike, but they're more threatening. But for Black girls, it's this idea that there's this moral deficiency that really needs to be corrected. So we were really interested in seeing what were adult perceptions of Black girls. Were we seeing instances of adultification? So we surveyed 325 adults nationally and asked them very explicit questions about whether or not Black girls exhibited certain behaviors at different developmental ages. So we started as young as age 5 all the way up through adolescence, age 14. And our results are both surprising and not surprising at the same time. What we found is that these adults were conveying through their responses that Black girls at as young as age 5 were not as innocent as white girls at age 5. Black girls didn't need nurturing at age 9 or age 5. Black girls didn't need protection. And even at very young ages where we would not expect girls to have a sophisticated understanding, these adults were endorsing items that said that Black girls were more knowledgeable about sex at age 5. They were more knowledgeable about adult topics. So we're very similar to the work that we are seeing with Gualt and Sandra Graham, and kind of cultivating this idea that Black children are not as seen as innocent. We're seeing this very clearly, very explicitly stated in the adults we surveyed as it relates to Black girls.
So as far as the implications of these findings are concerned, we should emphasize the pretty large caveat that we did not establish causation. So we didn't establish the link between viewing Black girls as older and less innocent and criminalization. But we do have studies like Goff's that show that the same adults, including police officers, that view Black boys as older, that 4.5 years older that Chris talked about earlier, also are holding Black boys more culpable for suspected crimes. So we think it's pretty fair to suggest that now that we have evidence, which we will release as soon as we're done with writing the report. Always takes a little longer than you want it to. That we think there's a similar link. That our evidence that adults see Black girls as older and less innocent is likely to lead to harsher treatment. And as Maheen was just alluding to, of course we have data that shows that Black girls are treated disproportionately more harshly in our public systems. And that is true at virtually all points in the juvenile justice process. That is compared to their white female peers. But it's also true in schools as well, where Black girls are really wildly disproportionately disciplined and pushed out of school at rates that don't come close to their percentage of the population. So our call to action in this report is to become more aware of this phenomenon for Black girls and to take steps to overcome this form of bias. And we do hope that further research will be done to do a deeper dive into that causality and really explore that link between adultification for Black girls and harsher punishment. But I just want to, before I stop, one really important thing to highlight that builds on what Jamelia was just saying is that this isn't just simply studies like Goff's for girls. Adultification for Black girls looks different than it does for Black boys. So I just want to highlight what Jamelia said. We are seeing a difference as early as age 5. And if you think about that, we urge people to consider the impact that adultification might have on such young girls that's at such critical periods of growth when girls are learning about the world and their place in that world. They are being treated as people that compared to their white peers are not deserving, do not need nurture and protection. And the second thing to point out as a unique subtext of adultification that's for girls is the degree to which society's perception of the sexualization of Black girls is part of viewing them as older. And that's a key piece. It's part of stereotypes and bias that go back very far in our history. And we tried to capture that in the study, as Jamelia was saying, by asking about Black girls' knowledge of adult topics and sex. So it lies beyond the scope of our report, again, to prove this causality, but it provides really rich food for thought, disturbing food for thought. To name two possible implications of this, are Black girls blamed inequitably for dress code violations because of this sexualization subset of adultification? Are they blamed for their own victimization in gender-based violence by bias that would indicate that they're somehow complicit or consenting to the crimes that they're victims of?
Thank you. I think that is very important context in terms of just understanding before girls of color even touch the justice system, how they are being socialized and treated. I think we've had a lot of conversations about broadly how youth of color, but that piece around hypersexualization and the gendered nature of it is so necessary. And I'd like to turn it over to Professor Nanda to talk a little bit about how to expound upon what Rebecca and Jamelia have shared, but also to talk about how sort of the intersections of gendered and racialized bias play a role in decisions impacting girls, not only in terms of their initial involvement with the system, but decisions to kind of push them further into the system.
So thank you for inviting me today. You know, for girls being 33% of the population, girls are not researched, studied, or examined 33% of the time. So I want to thank Chris Henning and JDC and Georgetown for inviting us today and being part of this conversation. There's this great quote from a development specialist that says the way we treat children is how they think about themselves. And I think about that with the girls that I work with. So my work is heavily influenced by my clients, by girls I speak to in high school, in college, system-involved youth. I spend a lot of time talking to girls, and they find it really funny that this is what I research and study because this is their lives, right? So often I go into spaces to present data, much of which we're sharing with you today, and after hearing from them, I usually stop I stop the PowerPoint because it's really just their lived experiences that really reinforce that. So I really want to invoke that, especially building after Devontae's speech. It's complicated, right? All of this is really complicated. So when why it's so difficult to talk about girls is because it's both multi-institutional and multi-dimensional. And so the two just even those words, right? Like people are already like looking at their phones. So those two things need to stay together in order for us to really understand this. So as far as we can unpack why we see an increase of girls, we think it's two things. One is we think cops are increasingly considering status offenses to be more severe than they are. So status offenses are offenses, I think most of the people in the room know this. If you don't know this, status offenses are called status offenses because it's their status as a young person that is making this an offense. So for girls, about 50% of the girls that are locked up nationwide, some higher in higher places, is just for running away. So I mean, if you just sit with that statistic for a second, right? Like why a girl would run away from a safe home or potentially not safe home or run away at all. I mean, 50%. Curfew violations are also status offenses. So there's a lot of discretion that's built into that. So you have that compounded with the trauma, compounded with the individual bias and the systemic bias that we've been hearing about all day. So that's number one. Number two is the paternalism, the judicial paternalism that you see. Like, I'm saying judicial because I've recently been spending a lot of time thinking about judges and talking to judges and their perceptions of gender, but you really see that paternalism every step of the way. And it's reinforced by player after player of player. It starts in the schools. It might even start at home. It might even start in the community. It's reinforced in schools. And then they get into the court, it's reinforced. Right? So it's sort of just perpetuated and perpetuated on top of the bias, on top of the trauma. So now you sort of see like the increasing factors. Okay, so just to make it really concrete. So we see policing gender, racial, and gender norms in the school. We see it I went into a school recently where I asked the whole group of girls if they feel like they're treated different than boys, and every single hand went up. And then I just sort of took a survey, and most of them were really deeply concerned about their school uniforms. A lot of schools in LAUSD, and my kids' home school don't have air conditioning. It can be 100, that day we were there was about 100 degrees in there, and they want to wear spaghetti straps, but they're not allowed to wear spaghetti straps. And one of the girls said so poignantly, she said, they're sexualizing me, I'm just hot. Like, I just need to wear this spaghetti strap, and I'm not allowed to. So we see that happening. That's a real obvious example. But we also, in the report that I'm going to talk about later, the Black Girls Matter report, Black and brown girls, we found when we talked to stakeholders, were perceived to be more mature and self-reliant in ways that were actually unfair to them, which actually we found in like high achieving and moderate achieving girls actually made them withdraw more from school. So, you know, we spend, I think, a lot of time thinking about system-involved youth, but there's, you know, girls that are pre-system involved youth, and that's what most of my thinking about this work is it's that beginning stage where you sort of see where this ship is going and you really want to just stop it, and you see sort of that play out in the school context. Okay, and then with police officers, we know from a kind of slightly outdated survey that police officers and probation officers, when looking at a whole bunch of studies, said that when they saw that boys were doing drugs, that it was a lifestyle choice, but that girls' drug choice was contributing to criminal behavior and strong concern for unprotected sex and relationship with boys. And those are sort of the themes that emerged. It also showed that juvenile records often show bias in describing girls as big, as loud, as criers, as manipulators, as promiscuous. I see a lot of like cringing, especially of the females, right? Because we've all heard some version of this. Pouting. And of course, with the big, there's obviously gendered and racialized notions of that, given that black and brown girls hit puberty at different ages, right? So there's like conceptions of that have to come into play, right? So this is complicated. You see what I'm saying? It's really complicated. And then a couple more that I want to talk about is a couple years ago I did an article about what they were finding with judges and kind of their perceptions of judges when they surveyed judges. So unfortunately, a lot of these studies are binary. They're just black and white girls, recognizing, of course, that there's multiracial dynamics to all of this. So I just want to cabin that because I recognize the limits of all of this, which is why, again, we need more people to talk about this so that we can make sure we get into all the different communities to study these. But these were the adjectives that were used to describe girls: white girls, Hispanic girls, and black girls. White girls were passive, in need of protection, non-threatening, and amenable to rehabilitation, which is important, right, given that that's the whole theme of this conference. Black girls, however, were independent, aggressive, loud, pushy, rude, sexual, unfeminine, violent, and crime-prone. Hispanic girls were dependent, submissive, family-oriented, domestic, and highly sexual. And if you really unpack some of those adjectives, you see that there's paternalism to a lot of the adjectives describing white girls and to some extent Hispanic girls, maybe less so. Black girls, more of a punitive sort of nature to describing that. And because I don't know if James Bell is still here, but his organization did this amazing history of adoration of a question, which traces like the juvenile court origins. And if you look in 1899, when the juvenile court was actually created, the list of sins for sexes was divided. And for girls, it was frequent attendance at saloons and pool halls and the use of indecent language. In the 30s and 40s, it was girls were hauled off for being morally depraved. And in the 60s, New York let juvenile courts have jurisdiction for boys until 16 and girls 18. We know, obviously, that recently changed. And then in the 70s, they changed that. But really, the biases are really there. So the reason I want to talk about that is because it brings me to our current research that I'm doing in LA, where we're interviewing juvenile court judges. And we're in the very beginning stages of it. It's very early. And I'm just going to say Southern California, so as not to identify the court or the judges. But these are a couple of themes that we've seen emerging. These are themes that my students and I have pulled out of the many, many interviews and court observations that we've done. There are a couple of themes. One is boys will be boys. There's sort of a like boys will be boys versus the girls are sort of a policing. There's a moral judgment about homeless and transient families with a lot of assumptions being made about the mom. So a lot of the way in which we treat moms. So I think that like we spent a little bit of time today talking about the individual child, but these children are all from communities and families and parents. And often sort of the way in which we treat the mom is, I think, just as important as the way in which we're treating the child in the courtroom. There's a lot of conflating of sexuality and gender performance and gender identity. So the judges, when you ask them questions, get really confused by what you're asking them. Right? So we have to say, well, first we're talking to you about gender, and now we're talking to you about like sexuality, and they get really confused by that. Like the question, even in of itself, they conflate the two. And then of course the paternalism. So if I'm going to just read a few of these, I'm going to take up more time and concede my time in the next session. Boys will be boys. One youth had a sexual battery charge, and he was the only one that the judge spoke to as a child. The boy was 12 when the act occurred, and the judge said it was ridiculous that they even had him in court. The judge said when he was younger, they called it grab-ass Fridays and thought it really wasn't criminal. Okay, so this was just a couple weeks ago. But the same judge said boys, he declared, joined gangs for protection in their neighborhoods, but that girls joined because they were attracted to those type of boys. Conflating sexuality with gender. This is from my student's notes. He stated that he looked at the underlying crime of the student, not their gender, which I think he meant sexuality. That's what the student said. He does not care if there is a girl who steals makeup or a boy who steals makeup. You look at the action. He continued that, and it's interesting that he brought up makeup, right? He brought makeup as sort of the example that he gave. He continued that he has kids in his courtroom who come in, and you know, full-blown gay and everything. You want me to call you Paris instead of Trey? Okay, I'll call you Paris. Now sit down and shut up. Okay, housing status. Mom has serious attitude. This is from a DA in the courtroom that we witnessed. Mom has serious attitude. Stepmom says she's homeless, transient, going to take her to Texas. She obviously needs help. We had observed a public defender frustrated that the mom didn't know where she lived, and so asked me if I could give mom Google so that mom could figure out where she lives. And mom, mom was homeless and was embarrassed to tell the court that she didn't have a home. So it wasn't that she didn't know where she lived; she just didn't feel comfortable telling the court that. And then the last thing I'll say is the paternalism. So a lot of she's running the show. We have to control girl from running the show. You hear a lot of that from the judges, and you see it a lot in the courtroom. I'm sure people who practice in juvenile court see and hear this all the time. But the last one I'll say is really interesting because it implicates all the different systems. When we talk about the school, when we talk about reinforcement. So judge scolded the youth throughout the hearing and said, how do you expect to be successful? This is a female. You think people hire stoners with an education who just wander about? And then the public defender argued that the child had not received their IEP, which is a disability, invoking their disability rights. And the judge said IEP means services caring. Judge turned to the youth and said, why aren't you going to school? And that without going to school, the girl was a recipe for failure. And these are all observations that we've done maybe in the last like two or three months. So, again, like we treat children the way we expect them to view themselves, and this is sort of what our girls are facing in the courtroom.
So I do want to talk about trauma, but you brought up something that, actually all of you brought up something that I think you touched on, Jamelia, at the beginning, which was this idea around attitudes about black and brown girls, particularly black girls, as sort of morally dysfunctional. And then there was sort of this idea that, Jyoti, you really elucidated around sort of not fitting traditional notions of femininity and a lot of those attitudes that people had. And National Women's Law Center did this beautiful report a few years ago called Unlocking Educational Opportunity for African American Girls, and they did this study where they said that black girls actually viewed themselves more commonly or more often as leaders, right, than some of their other racial counterparts, but that there weren't necessarily programs in schools to sort of build on and recognize their behavior as leadership. So Jamelia, I kind of wanted to just take a moment to turn to you to just kind of expand on some of the things that might come up in terms of how that links to attitudes around moral dysfunctionality.
So that's a great question. So my thoughts are, black girls are in this unique, they're this double-edged sword. There's this paradox. On the one hand, they're seeing themselves as leaders, right, and attempting to assert themselves. But you can't assert yourself too much because then you're an adult, and then I'm going to treat you like an adult, and I'm not going to allow you the protections that we give children. I'm not going to allow you the opportunity to make mistakes and be wrong. So they're in this unique position where they do have the leadership capacity if we think about leadership creatively, and we don't try to kind of put them in this box where we say, oh, so you want to be an adult now? Oh, you think you know things? Okay, great. I'm going to treat you like an adult. And you're not expected to make a mistake, and you're not expected to have these kind of just the transgressions that we know accompany childhood and adolescence. And so kind of the conversation in schools with teachers, people who are doing ethnographic research, is teachers are constantly, educators are constantly trying to kind of control and present the surveillance over black girls that, in essence, in spirit, I think it's because they want to protect them, but actually it does more harm. It actually funnels them into kind of the discipline system and further excludes them from the educational system so they don't benefit from the opportunities. So as opposed to us changing our system and the way we go about educating girls, or black girls, we tell black girls, no, you need to change and you need to fit into this parameter that we've decided that is in terms of gender expression, just vocal expression. And we often mislabel their assertiveness as aggression. and their defiance, their willingness to kind of put forth their voice, we say they're being defiant. We're saying they're being argumentative. And instead of saying, wow, you're really trying to find your voice. So I think that is what's happening in the education system. So even though girls are seeing themselves as leaders and they're seeing themselves as asserting themselves, it becomes this double-edged sword where they lose their protection. So they're constantly blamed for being who they are and establishing their identity.
Thank you. I'm really glad you brought up the concept of blame, because I do want to turn to Rebecca for a moment. One of the things we've been talking about is just generally how Black and brown girls are treated in schools, right, and treated in the community. But we know, Rebecca, you worked with our organization, Rights for Girls, and the Miss Foundation a few years ago to put out a report called the Sexual Abuse to Prison Pipeline. And you recently also put out a report about gender and trauma, particularly as it impacts girls in the juvenile justice system. So I was wondering if you could talk a little bit more about sort of how trauma specifically is actually driving girls into the juvenile justice system.
Sure, I appreciate that question. We love reports. So this brings two of them into play here. So it's critical to view trauma through a gender as well as a race lens. Girls experience trauma in ways that are unique to boys in terms of the prevalence, in terms of the rates, in terms of the types of trauma. So a lot of people in the room might be familiar with the ACEs survey from the late 90s. The ACEs stands for Adverse Childhood Experiences. And two physicians developed a scale in which they labeled 10 different forms of adverse childhood experiences that children might experience. There are plenty more than 10, but that's what they started out with. And studies that have been conducted since that time on girls in the juvenile justice system in particular have shown that more girls are reporting every single one of those 10 forms of trauma. So if you look at a bar graph, the girls are always taller. Their bars are always taller than the boys across all 10 categories. And the other thing that we've seen in multiple studies is that boys tend to be, they're assigned 1 point. The participants in these studies are assigned 1 point for every kind of trauma experience, not how many times, but the kind of trauma that they experience. Boys tend to score 0 through 4, maybe 0 through 5 in the juvenile justice system. And girls are tending to score in the 5 to 10 point range. And that's really the most vulnerable, extreme end of the spectrum. And that's really significant because the other thing that the ACEs study showed is that there's a dose-response relationship between the number of forms of trauma you experience and long-term physical as well as mental health outcomes. So there's these critical pieces. When you score between 4 and 6 and then between 8 and 10, the chances of your having not just depression or substance abuse or even suicide go up, but also cancer and liver disease. So there's an extraordinary impact to this prevalence of trauma for girls. The other thing that's been studied within the ACEs context for girls is that it's the category of sexual abuse in which girls, probably unsurprisingly, by far disproportionately outscore boys. So one study of girls in Florida by the OJJDP showed that 35% of girls reported experiencing sexual abuse compared to 8% of boys. And that's really consistent with other studies that have looked at the prevalence of trauma in girls. So in writing that study that you referred to called the Sexual Abuse to Prison Pipeline, we took that category of sexual abuse and highlighted how the experience of sexual abuse for girls, especially girls of color, can lead to a pathway into juvenile justice. And what that means is that, stripped down to its essence, girls are blamed and criminalized for the sexual abuse they are experiencing. So think about the injustice of that. So instead of being provided with supports and services as victims or survivors of sexual abuse, they're put into the juvenile justice system. The starkest example of that is sex trafficking, when girls who have been coerced and are not the legal age of consent are still detained on charges of prostitution. It's not limited to sex trafficking, though. Status offenses also comes into play, as Jyoti was referring to earlier. Girls are disproportionately picked up for status offenses, and there's a failure, as you were saying earlier, to address the root cause. Why is that girl running away from home? What is she running away from? Why is she truant? And the narrative that lies at the heart of most of the underlying stories is sexual abuse. And I would just add that even though we called it the sexual abuse to prison pipeline to sort of echo the school to prison pipeline that's largely centered boys and boys of color, it's really a cycle that can feed on itself. So we viewed it in our report as girls who are put into the juvenile justice system do not receive the supports and services that they should as survivors of trauma. The institution itself may re-trigger the trauma that they experienced to begin with. Girls may also experience new forms of abuse while in the system. And when they're ultimately released, again, without critical supports needed for survivors, they are more vulnerable to entering the juvenile justice system at a deeper end in the system, and the cycle can feed on itself in a harmful way.
Thank you. I think that conversation around trauma is one that often comes up when people think about girls and the juvenile justice system. But I think the thing that we don't always think about is how then the justice system and some of the systems that our kids are just placed in, right, can be sites that reproduce that trauma. So I was wondering, and I'd like to first pose this question to Jyoti, but allow all of you to kind of expand upon how our communities, our justice systems in particular, can be sources of, we had this conversation earlier about implicit versus explicit bias, that are systems that are explicitly, and maybe not intentionally, but certainly explicitly enacting traumatic actions against young women and girls.
Want me to start? Mm-hmm. So in our Black Girls Matter report that we did, and Kim Crenshaw was a primary author, who was secondary author on that, and Kim did something really interesting with the data. So historically, the data around suspension rates was always contrasted with Black boys versus white boys. And you'd see all girls and Black girls. But what we did in this report, which was really her vision, which was, again, complicated, so you have to stay with me for a second, is that we highlighted the suspension rates for Black boys versus white boys, and then the suspension rate for Black girls versus white girls. So a couple of highlights. Suspension rates for Black boys was 3 times, and this was in Boston and New York, compared to white boys. But the suspension rate for Black girls was 6 times more than white girls, right? So this is where we're talking about like unpacking. Ms. Lopez earlier today was talking about using the data, in ways that is really useful. And that's really where we found like unpacking that was really contrasting and highlighting for us that something was specifically happening with these Black girls as opposed to white girls. That was different than just sort of overall Black suspension rates and white suspension rates. And there's a lot of statistics that go through that. In Boston, there was 3 times as many Black girls enrolled in white girls in school, but they were 11 times more likely to be suspended. So for Black girls, it was 340 cases versus 30 cases for white girls. In New York, it was 9,076 cases versus 884 cases. And these were because of the data we were able to receive from Boston and New York. So I would imagine that if we did it in other cities, that it would be similar. So I think to your question, why that's important is to the question is that, and my concern, of course, with, I think it's really important to talk about the trauma that girls experience and the ways in which we respond to that trauma and the resilience, but we heard from Devante too that the systems that these children are in, starting from the school all the way through the systems, even if they may not necessarily reproduce that trauma or recreate that trauma, that's not for me to decide, that's really for the psychologists to decide. They definitely exacerbate it, and they definitely contribute to sort of the continuation of that. And we see that with zero tolerance policies in the schools, and our studies have shown, both this study as well as talking to girls, I talk to girls in college who grew up in South LA in the schools that I now work in, who tell me that they remember like yesterday the interaction that they had with their school resource officer and how it has stayed with them, continued to stay with them, even till college, where like tears, flow out of their eyes when I ask them what they remember about their school resource officer. So we have this, as people in the room know, we have this whole school security apparatus that's in play now with the metal detectors and a great campaign in LA called #StudentsNotSuspects, which even just having to have that hashtag to me is really profoundly sad, right? That you actually have to say that in the schools these kids feel like they're suspects. And we know that for girls, that has a traumatic impact on them. And both stakeholders, when I mean stakeholders, I mean teachers, administrators, and girls themselves have told us that as a result of those zero tolerance policies, they're more likely to drop out, they're more likely to react negatively, and that when they do act out as a result of that, then they're penalized. So we think about zero tolerance policies, right? We just sort of throw that out there, but we don't really think about how that reproduces itself on a really micro level.
You want me to go next? I'm glad that you mentioned police in schools, because I think that's something that hasn't been raised all that much today and is critically important. And I'm actually working with Monique Morris, who you talked about before, and we've talked to girls of color in the South as well as school resource officers themselves about their interactions. And the school resource officers have expressed actually a hunger for more tools to think about and interact with girls of color. Girls of color are just not in the conversation when police officers are trained, at least the SROs that we've talked to. There are no curricula that we've discovered yet that talks about issues particular to girls of color. And they have actually said, we can't wait to see what you come out with, because we'd love some training. There's a real lack of training on cultural competency and bias for SRO officers, SROs, that needs to be addressed, as well as the lack of information given to them to connect girls of color in schools to resources in their community, which would be a critical step to avoiding entry into the juvenile justice system.
Can I just say there that I haven't conceded yet that school resource officers need to be in schools.
Right.
I haven't conceded that yet. I might be like the only person
of course.
left,
we couldn't agree more. Yeah. We're talking about what to do with the situation that we have now, and that it needs to improve.
But perhaps part of that conversation is not having them there.
Well,
like perhaps why they shouldn't be there.
And it's an important point in the justice context, because based on what we know about what girls are coming into the system for, predominantly, not always, right? Not that any child needs to be. I know I'm in a room of folks that want to free all the children. But I think that, there are quite a few girls who are really there more so because people are afraid for their own safety as opposed to them being a quote-unquote threat to public safety. And so I think to your point about sort of whether, there's always a question of working with what we have, but also acknowledging that some of our efforts, particularly around girls, need to challenge some of those assumptions.
Although the theme itself remains true, that systems should become more trauma-informed.
Absolutely.
So schools as well need to become trauma-informed, even without officers there, rethinking traditional discipline and recognizing trauma.
Absolutely.
Okay, so 5 minutes. So what I would just say as the one psychologist here is that in thinking about how we support girls of color, I think the point made earlier about accountability and documenting and making database decisions needs to continue. That effort needs to continue, keep moving. And we're at a state where we don't know if that will happen. So it is on us to employ these systems to work together. And there also needs to be what we talk about as wraparound services. So we have these entities, so we have you all in the juvenile justice system, we have the school, we have mental health, but we need to be convening boards where we're having these wraparound services and we're talking about how do we make sure that girls' mental health, their physical well-being, how do we take a preventative stance before they even get to the point where we're dealing with the juvenile justice or judicial system, right? And the only way we do that is we start to have wraparound services, which involve system-level changes. It means school discipline reform, and we're talking about that with restorative schools, we're talking about that with PBIS, but that's not enough because we know that there are some girls of color, actually all children, quite frankly, let me just put it out. There are children who need more wraparound service. We need more integrative kind of support services to kind of prevent and disrupt the inequities that girls are experiencing. So I think we need to start re-envisioning how we are all going to come to the table at once to kind of support these girls of color as opposed to just operating in our own silos. And that's why we have these gaps. That's why we're missing and girls are kind of slipping through the cracks. So we need to re-envision what it looks like to support childhood. How do we keep children remaining, the right to remain childhood? How do we support childhood? And we're gonna all have to come to the table. And I don't think we've really done that. I think we still talk in silos about what we need to do, but we've not re-envisioned that, so.
So you started us off on really my last, so I just want to give Rebecca and Jyoti an opportunity to kind of add to that in terms of, I want to open it up for questions, but quickly, there are a lot of reports that we've mentioned that offer some best practices or strategies, but I wonder if there's anything else that you kind of want to share as a lasting thought in terms of what you are asking this audience. What is the call to action in terms of pushing for a contemplation of girls that just really hasn't happened yet?
Dr. Blake at every school would be nice.
Absolutely. I love it. I'm working on training them.
I mean, I think we need more counselors in the schools than police officers. I know that sounds simplistic, but in terms of actual budget and people need to fight for that on a real local level. Like, we fought really hard for my local elementary school not to have a police officer, and it was difficult after all the shootings. That they wanted that. So we have to fight on a real local level for that. So that's one thing. But two, what we're finding with my clients is a lot of these resources that are in the community don't apply to kids that are in the delinquency system. There's exceptions carved out for a lot of these programs in LA County because they need to produce certain outcomes, right? And so the programs are not full. But yet my clients don't have programs and things to do after school. So I think that both again, being in the system, and then once they're in the system, thinking hard about what those programs are. And the last thing I'll say is that whoever decides to come up with, I mean, we're all trying to think now in LA about what are some of the diversion and ways to do this for girls, that we need to have these girls at the table. Because when you talk to a group of girls, they have a lot of really great, simple, inexpensive ideas of how we can improve. And I feel like a lot of times we're just not asking them.
I would just add to the mental health services, reproductive health services is key as well for girls, and that's often overlooked. And multidisciplinary, speaking of getting out of silos, multidisciplinary approaches to sex trafficking and other issues involving girls, where when the juvenile justice and the child welfare system communicate better, we see much more effective change.
And one thing that I want to pull from all of you, though, that I'm hearing is really a call around us individually contemplating girls, right? And thinking about how all of these efforts do impact girls, that all of us are dealing with young women and girls on a daily basis, and oftentimes because they're not necessarily the majority, although they're climbing, that we are thinking about what their unique needs and experiences are. So with that, I think we can open it up for questions, maybe one or two, if folks have them.
Could one of you talk about what happened in Massachusetts as an example in the last week with charter schools?
With the hair braiding?
Of how big the problem is.
Absolutely.
Yeah. Is it with the girls who were, do you know?
Yeah.
You go for it.
No, go ahead.
No, I just have a Twitter. I just have a snapshot, 40-character depiction. Go for it.
There were two girls in Massachusetts. Do you know the name of the district, Adam?
It was a charter school.
It's a charter school in Massachusetts. Two young black girls who I think are juniors, who were forbidden because of their school code of conduct in the charter schools. Again, charter schools, that's a whole conference in and of itself. Charter schools versus public schools, and following the rules, they weren't allowed to wear their braids. And so the girls thought that they disagreed with the policy, so they've gotten multiple detentions. I think they're up to 6 or 8 detentions. One was kicked off the track team. They're not allowed to go to the prom, but they decided that they're going to fight, with the support of their parents, that they're going to fight this policy. And so, again, I think that, again, if you talk to girls in these schools, they're very aware of how these policies, and that one is a very obvious example of racial and sexual norms being policed.
Yeah, policing the decorum of black girls is prevalent, and that's an example. What does having your hair braided, what does that have to do with anything? What outside of you're just not kind of following the gender norms that are set up, the racialized gender norms, right? Because we know not everyone braids their hair that way. And so what does that say? So this is something that we constantly see I've seen it in my work, policing the decorum of black girls and putting them constantly under surveillance for things that are really minor that then escalate, right? And it does a couple things. It makes them not engaged in school, so not seeing themselves as leaders, right? So it can turn people away from systems of support. Or two, it increases the likelihood that they will continue to rack up office discipline referrals, and depending on that school, you know, put them to the next level, right? So now they're missing instructional time. So it's this cycle, it's this vicious cycle, and it's because in our society, talking about paternalism and racism, we have this tendency to want to correct Black girls and Black women. We want, there's something morally dysfunctional. There's something wrong about the way what we look like, the way we dress, the way we speak, and there's this constant push that we see very early on from our survey and even in, you know, the school discipline work, that we need to correct this. And so there, I guess a bigger call is that we need to address this kind of systemic racism and sexism that is permeating all aspects of our social systems. And we're seeing it, I think we always knew this occurred, and we see this, it started first of all talking about in the workplace, right, where people talked about this in discrimination, and then we talk about it in higher ed, but now we're seeing it in our school systems, and we're seeing it, so this is something very pervasive that we need to really tackle, and we need to dismantle it, and it's gonna be uncomfortable. So.
Thank you, left us on a beautiful
Yes,
note.
agreed.
So thank you so much.
Thank you.
I personally have a lot to learn from this panel. We spent a lot of time thinking about the sources of racial disparity from other stakeholders, from ourselves as defense attorneys, from prosecutors, from police, from judges, but some of the more subtle ways that racial disparities are perpetuated through the system is through forensic evaluations and forensic screening instruments and the like. So we really wanted to incorporate this panel or this fireside chat to help us get some insight into that. So we have our wonderful Eduardo Ferrer from the DC Lawyers from Youth, who is going to moderate this panel. So thank you very much. Have at it.
Thank you. Thank you all very much for coming back. I know risk assessments was like the draw for the entire conference. I, like Chris, am particularly excited about the session and particularly grateful to be moderating it because of how risk assessments have proliferated, and the use of risk assessments in particular has gotten more and more common in the juvenile justice world. Stakeholders utilize risk assessments for a host of reasons. We use them to predict a child's potential for successful rehabilitation, to assess a child's likelihood of recidivism, to determine when a young person should be detained or should be incarcerated. And when we heard this morning about the implicit and the explicit bias that exists in the system, risk assessments were really one of the tools that I think a lot of people were hopeful would provide some of that structure to rein in some of the bias that exists in our system. And I think depending on who you talk to stakeholder-wise, we've had different success with risk assessments. And so what we're going to try and tease out during the panel today is what is successful, what's working, what's not, what are these, and what do we do about it? So we are very blessed to have Dr. Daniel Murray and Dr. Sarah Boyd joining us today. Their lengthy bios are in the program materials. I highly recommend that you review their bios so that you get a better sense of who they are. But both of them are fantastic, and so thank you both for joining us today.
Thank you.
We're going to get started off with just laying the groundwork, right? So we're going to introduce risk assessment. So Dr. Murray and Dr. Boyd, when we talk about the term risk assessment instruments, it seems to be a pretty broad term that covers a wide variety of instruments or different tools. Dr. Boyd, can you start us off today by explaining what a risk assessment instrument is broadly and the various formats of risk assessments that we use in the system?
Right, so Dr. Murray is going to get into a little bit more of sort of what the sort of structure of these different instruments looks like. But broadly speaking, when we're talking about risk assessment, we're talking about two main categories of risk assessment. One being the kind that you'll see that is strictly actuarial. So by actuarial, I mean that they're using variables that have a statistical relationship with an outcome of interest. So for example, your car insurance being calculated, basically plugging in age, marital status, things like that, you get a number. It's not based on an interview or anything terribly subjective. And so the actuarial instruments are the ones that we see being used sort of more institutionally to look at things like level of placement within a facility, and that sort of thing. What we are going to be able to focus on more today are the kinds of evaluations that we are asked to do in risk assessment, which is a forensic psychological risk assessment evaluation, which isn't, we do incorporate some actuarial instruments at times depending on the circumstances, but the psychological evaluation process involves more judgment because we aren't simply plugging numbers in. And there are lots of reasons for that. Particularly with juveniles, you can't just plug in numbers. With kids, for lots of good developmental reasons that have been demonstrated over and over in the research. So broadly speaking, we have those two kinds. We're going to focus on the latter kind, the forensic evaluation risk assessment. And so, as I said, the first kind are more used in these institutional type environments. And the kind that we're going to be talking about can be used at a variety of stages throughout the process of adjudication. A lot of times what we're seeing in violence risk assessment is we're seeing it after, basically prior to sentencing. So that's the kind that we're probably going to be focusing most on today because that's most of what we do.
Right. And Dr. Murray, can you explain the varying theoretical structures behind some of these different types of risk assessments, as well as the pros and cons to the different structures?
Sure. So a lot of these efforts go back, and just to give some context, a lot of these efforts go back to the law's requirement that we make inferences about dangerousness. And you attorneys know this, right? You know, going way back, there's always been a request for inferences about dangerousness. And historically, clinicians have agreed to make those inferences. The problem is dangerousness is it's a really ridiculous concept, right? Because the way the law operationalizes it, dangerousness is a fixed attribute of a person, right? The law is trying to decide, are you dangerous or not dangerous? If you're dangerous, we civilly commit you, or maybe we make you eligible for the death penalty in certain states where dangerousness is a requirement. But it's dichotomous, it's yes or no. And clinicians would go along in this and opine that somebody's dangerous. Now, more and more clinicians have started to say, wait a minute, this just isn't really how people work. Risk is a function of person, but also context and situation. And each of us is probably dangerous in the right context with the right substances. And many people who look dangerous are not under the right structure and so forth. So historically, when clinicians were asked to assess dangerousness, they did it in sort of a non-transparent, invisible way, right? I would sit with you for a while, I would talk with you, I would kind of stroke my beard and make some inferences, and I would say, Water is a dangerous guy. How I did that, I don't know. It wasn't really transparent, and I might do it a different way from Dr. Boyd, but clinicians were sort of trusted to do that, and there wasn't a real explicit model. And research more and more showed that we weren't good at that, right? Historically, we just weren't that good at that. And so there have been efforts, research-wise, to make this more scientifically sound. And the strongest push on this was actuarial measures. Again, those are those mathematical models, much like your car insurance company would use. And those might use some very simple, observable, or findable characteristics like age, past offense, things like that. And frankly, those sometimes would predict better than this kind of invisible, subjective clinical judgment. So we initially had unstructured clinical judgment or strict actuarial methods. Both of those kind of have their strengths and weaknesses. Actuarial methods can't consider important data that's not in their formula, but they are more structured. They reduce certain biases, maybe. So over the years we had those, but more and more there's been kind of a middle ground that tries to maximize the strengths and minimize the weaknesses of each, and that's sort of a structured professional judgment, where maybe risk factors are indeed based on research. They're not whatever idiosyncratic ones I might have thought of when I was interviewing you. They're at least based in research, but there is some clinical judgment in terms of applying those to the case. And different instruments will structure these more and less, sometimes just identifying the risk factors, other times identifying how they're scored and totaled, and even how they yield an overall risk conclusion. But that's kind of the spectrum that we have as a field.
Great. Dr. Boyd, I want to follow up on a point that you mentioned, that for young people in particular, can be more difficult to use instruments. Why is that?
Well, there are a couple of reasons. So for many years, what we've done, I think both as a profession, when I'm mixing in psychology and the law. And in terms of our practices, as a society, what we've done is we've considered juvenile offenders to just be like slightly smaller adult offenders who are on a trajectory that's already described and determined by the behavior they've engaged in. And so what we did was we took the research that we had and the measures that we had created for adults, and we sort of generalized it downward and said, this is what we found about adults, probably also true for kids. Well, it turns out these things are not true for kids. There are really important developmental considerations. For example, during adolescence, but especially between the ages of about 14 to 17, because of the way that brain development occurs, the timelines of it, kids are much, much more sensitive to environmental and social factors than adults are. So, for example, there's a series of studies that show that the mere presence of another adolescent peer increases the likelihood that an adolescent is going to make a risky decision. A lot of the studies that have been done on this have focused on like driving behavior, but you also see an uptick in all kinds of risky behaviors during that time period, like suicide attempts, unprotected sexual behavior, all kinds of substance abuse, all kinds of risky behaviors have this uptick during this time period when kids are really vulnerable to these social and environmental influences. And so that's something that's really important with adolescents and juveniles that we weren't really taking into account very well. Again, we were going back to this dangerousness model in our minds where we're thinking about this is a static quality inside this individual that's not going to change, that's part of who they are as a person, instead of looking at where the kid is, who the kid's talking to, what substances the kid's taking could be influencing what we're seeing, because then that draws lines toward potential points of intervention. So we were treating kids like little adults. And so that was one of the things that we were doing incorrectly. The other thing is that I think it's a useful point is that when we're talking about risk, we have basically sort of three broad categories of risk factors. One are, risk factors, so these tend to be, static factors. These tend to be a lot of times historical factors that aren't necessarily changeable by intervention, like the person's age, number of prior offenses, things like that. The second category is dynamic, which are typically changeable by intervention. So it might be presence of a substance use disorder, being around peers who are getting in a lot of trouble, things like that. And then the third category is like protective or sort of buffering positive things, resiliency in the personality, that sort of thing. So in adults, we focused a lot on static factors. Those were shown to be pretty clearly linked to these outcomes of interest like reoffending. We assumed that it was equally important to focus on static and less so on dynamic in kids, when in fact the opposite is true. We're more and more finding that we really need to be focusing on these dynamic factors for adolescents, which really maps on well to the purpose of juvenile courts, which is supposed to be primarily rehabilitation. But I think as a field, we are still kind of struggling to make that transition to stop thinking of juvenile offenders as just smaller adult offenders and really take into account where they're at developmentally and how the research findings on adolescents and juvenile offenders really differ significantly from adult offenders in important ways.
That's great. I think that's a great transition to our next question, because I think one of our big hopes, at least from kind of the policy and the defense community, was that when you look at these factors, they would be applied in an unbiased and a race-neutral fashion. But what we've ended up seeing is that risk assessment instruments rely on a variety of factors that seem race-neutral on their face, but are actually proxies for systemic racism, implicit bias, explicit bias, et cetera. And so not many, not all, have a disproportionate impact on kids of color, because then we end up deeming them higher risk, or because we deem them in higher need of court-based intervention. So can you explain how seemingly race-neutral factors can serve as proxies for prejudice and paternalism in our system?
Yeah, so there's several ways this happens, and again, could spend days on this, but one of the most simple and straightforward ones is just the math itself. And so what I mean by that is this. So many of the actuarial instruments, the things that the juvenile justice system has really embraced as a way to apparently reduce bias, they try to take simple, straightforward factors that don't require a lot of judgment, factors that are readily apparent in a kid's case file, and use those mathematically to predict an outcome. okay? And that's promising, right? On the face of that, that's a lot better than me sitting with you subjectively and making whatever kind of inferences I might make. So it sounds very good. But we have to remember a couple things. One is that everything in that file, right, prior arrest, whatever information is there, may itself be shaped by certain disproportionate racial treatment, right? I mean, it may be shaped by racial biases. And so to then predict another outcome, such as recidivism, that is itself also shaped by racial biases, is basically what we'd call scientifically an inflated correlation, right? It's taking two things that have a third covariate influencing them and saying, wow, look, these look really connected, while not looking at that third thing that's influencing it. You know, it's almost like, if we think of racial bias as kind of an environmental toxin, okay? And it's really kind of present everywhere and it's seeping into anything. We might imagine a situation where somebody is trying to make a protective device for a environmental toxin. And they go into a factory and they use the right fabrics and the right materials and they come out with a mask or a bubble suit or whatever it is. But if that was formed in a factory that itself was stewing in all these environmental toxins, those things are still tainted, right? And it's a little bit that way with our actuarial instruments. We say, look, this is like pristine, you know, this is protective. And there's some good theory behind that, but if the factors themselves are already tainted, you know, what looks like good prediction is actually inflated prediction. So there's that kind of mathematical stats 101, test development 101 reason that some of this happens.
And Dr. Boyd, can you give us a couple of concrete examples as to how this plays out?
So the quality of the actuarial instrument is, you know, the instrument is only as good as the items that comprise the instrument, like as Dr. Murray spoke about. And the other thing that seems to be the case is that different items in these instruments predict more or less well depending on where this kid is coming from. So they might predict more or less well depending on the gender of the kid. We've overwhelmingly focused on boys and not so much on girls. The child might have a significant disability, which we know is kids with disabilities are really overrepresented in this population. We don't necessarily know that this instrument is predicting something for this child with this kind of disability or this language issue. And so we know that some instruments, you just have higher rates of endorsement depending on where the kid is coming from. And it's not just by race, it's also by socioeconomic status. So class is a massive factor here as well. So the couple of items that I often focus on are like parental criminality. So we're often looking at, theoretically, the idea is that if the child grew up in a home where the parents were modeling criminal behavior and attitudes that involve you know, not a lot of confidence or interest in like mainstream authorities and rules, that the kid's then going to pick up on that. But the one that I think tends to be most troubling for me is an item that sometimes gets called community disorganization, but what it comes down to is looking at the neighborhood the child lives in. And the idea that the neighborhood that this child lives in and of itself is a risk factor. So obviously, if we use that, we're going to be systematically disadvantaging kids who come from neighborhoods where they're starting from a disadvantaged place. And I think a lot of this, too, is there's this underlying problem that we're using these actuarial assessments in this very and even sometimes the structured professional judgment instruments in this mindless way, where instead of looking at the instrument, which in the case of the Savory, which is the one we probably use the most often in violence risk, instead of using it the way that the test developers and the manual tells you to use it, which is this is a tool to figure out where this child needs help and intervention, right? Because it's not always true that more intervention is better. Just like medical procedures, psychological interventions, and psychosocial interventions have potential risks, just like they have potential benefits. And you know, more is not always better either. We know that the more deeply involved kids get involved with criminal justice or juvenile justice interventions, it actually doesn't really benefit them in terms of reducing reoffense. It might, for a lot of kids, actually increase risk of reoffending. So we have problems with not only the instrument itself, but even a good instrument, which I think the SAVORY as a general rule in a broad sense is, people will take these items like community disorganization, like parental criminality, and even an item that's child maltreatment. Has this child been abused? And instead of using that as a sign, oh, here's an area where this child needs help, you have people who use it mindlessly to put a little tally mark in the bad kid column, right? To categorize this child, instead of using it to say, here's where we need to intervene in a way that's individualized to this particular child's need, and where the intensity of the intervention actually matches the child's risk level. So part of it is the instruments, and certainly some of the items are problematic, and some of the items perform differently depending on who it is that you're talking about. But it's also the case that sometimes these tests are these measures are just used incorrectly. They're not scored the way that they're supposed to, and then again, they're used to just mark up this little ledger, good kid, bad kid. You come up with a number, you mindlessly translate that into basically yes, no civil commitment, which is not at all the way that the instruments were intended to be used. But without transparency, the people who are on the receiving end of our risk assessment don't necessarily know that, because we, in a very, well, I'm a doctor and I'm telling you this is a high-risk kid who needs to be civilly committed. If other people aren't challenging that and demanding transparency about what about the items, how are you using it, reading the manual, nobody's going to be any the wiser that this is not actually the way this is supposed to be done. And it's complicated by access to some of these materials, but there are certainly some items that are problematic, but I think the larger problem is how we're using them. And so certainly I do think we should be talking more about what the items are, but even with that, a lot of times evaluators won't tell you very much about what risk factors they're considering. So I do think we need to have more of a dialogue about these risk factors themselves. Certainly community disorganization, child maltreatment, and parental criminality are good examples, but there are others. And so that's one of the areas where certainly I think it does come into play that items are unhelpful or themselves or just inappropriately used.
I think that ties nicely back to the analogy that you drew up, Dr. Murray, about if we build a suit that protects us in a toxic environment, the suit itself might be toxic. But it also dawns on me that if you put the suit on wrong, it's also not going to protect you, right? So can you talk to me, following up on Dr. Boyd's comments about how these tools are used, maybe about how bias seeps into that piece of it as well?
Yeah. And I'll try to answer that both at the level of the tests themselves and then the people like us. So, there's this claim that these tests can be good because they're scientifically validated. And these predictors are scientifically correlated with these outcomes. And I want to stress that we don't just want science, we want good science. You've all seen late night infomercials for maybe weight loss products or something where they say scientifically studied, and there I think you're probably savvy consumers. You don't think, wow, this has been scientifically studied, I need to go take some of those pills. You think, wait a minute, these are advertisers trying to get me to buy their product. And honestly, there's a little bit of this in our field, okay? And there will be some claims that, hey, these are scientifically studied, but you want to know how well. I mean, you really want to kick the tires on this kind of stuff. Many states will have their own individually developed juvenile justice system screening measure or kind of prioritization measure. Some of these may have good science behind them. Some of them may not. Most of them are not subjected to peer review. They're not handled much like other professional work is, where they're kind of written up in a study and sent out for peer review. They're just kind of in-house. And if you wanted to talk to the guy or a woman who developed it, that would be hard to do. And if you wanted to really kind of kick the tires and look at the data, that would be hard to do. They haven't been through that scientific process. So, in general, we're a little more trusting of measures that have been well validated empirically, and then also used in new settings. So a hallmark of good science is generalizability, right? Does this hold true not just in this particular jurisdiction, but if we take it out elsewhere? And by and large, state-specific in-house screening measures they're not really cross-validated in other systems. Now, some of these other violence risk assessment measures that are used more in forensic evaluations are, and that's a good thing. So we maybe have a little more faith in in those. But we want to be kind of good consumers of that science. This gets to there's some really new research on this, some of it not yet published, and it frankly surprised me a little bit, so I'll mention some of this. It compared some of these structured risk assessment tools that involve clinical judgment, the kinds Dr. Boyd has been talking about, with some of the in-house, more simple, structured, really look straightforward kind of screening tools. And frankly, to be honest, I would have thought that the ones that involve more clinician judgment would be more vulnerable to bias. Right? I just think there's a lot of room in there for clinicians to make idiosyncratic assumptions and so forth. And that's still true, and I can give you lots of stories of that if you want. But a strength of these is they're kind of based in theory, right? They're based in theories about intervention and how we might intervene with kids. In contrast, some of these very structured, sort of mathematically derived screening instruments they're atheoretical. They're not based in theory. And the risk is that they kind of capitalize on the peculiarities or the biases of the jurisdiction in which they're developed. And so what this research started to find is that, again, employing these in some jurisdictions and looking very carefully for disparate impact, they found that those involving clinical judgment and linked to theories of intervention actually didn't show disparate impact. Those that looked more objective and structured and strict did actually yield some disparate impact. And part of that has to do with items that really tapped into socioeconomic status, neighborhood, and even past offenses, right? Which themselves look like markers of behavior, but can also really be markers of policing, charging, judicial decisions, and all the things we've been talking about today.
And Dr. Boyd, would you like to follow up on that? Would you like to, we hear the term validation thrown around often in the field. Well, this tool has been validated, or this risk assessment instrument has been studied. How, and as a result, they kind of push back on this notion that they might be incorporating bias. Yes, they may have been validated, but all that's validating is that you're biased, or that there's bias built into these. So what would you tell folks who try and push back on the nature that these tools are strictly unbiased because they've somehow been validated?
Well, so I would say that if you're asking questions about how somebody approached a risk assessment, how did you do this? What instrument did you use? How did you score these items? What can you tell me about your process? Or this instrument, and their fallback is, it's a scientifically validated instrument, you don't really need to worry about it, that should be a massive red flag. That's an obfuscation, that's a smokescreen, and any decent risk assessment evaluator should be able to explain to you what their process is, and they should be able to explain it in lay terms, not burdened with a bunch of jargon that you're just supposed to be too intimidated by to follow up on. So we should be able to explain that. The whole idea that something can be validated and it's just like, well, I have a certificate, it's validated, so it's good forever. That's not really a thing scientifically. These instruments are constantly being validated. We have to replicate them. We have to also say, okay, well, it was valid for this population, but is it valid for this population over here? What about these kids over here? What about this gender minority, for example? If we don't know, we can't say for sure that it's valid for that population. So it's an ongoing process. And there are so many facets to validation. It's not a single construct either, that we're constantly having to take new approaches to try to understand, is it measuring the thing that we thought it was measuring? Is it maybe accidentally measuring something else? Is it valid for this kid? Is it valid for this problem? Is it measuring, so there's all these questions that we have to be constantly answering. And anybody should be able to explain to you, any reasonable person who is doing these evaluations should be able to explain to you, what do you mean by valid? What do you mean, is it valid for this kid? Particularly if there's anything unusual about the child, the juvenile. Like if, for example, I come back to the child with disabilities, particularly low IQ. There are lots and lots of instruments that we use that they have not included samples of kids with low IQs. So again, it becomes a question, valid for whom, valid for what? There isn't just a blanket, oh, it's valid, so it's good to go forever. That's not really I mean, you know, surely you've gotten me on this soapbox with this particular one, makes my eye twitch. But that is certainly an issue with some of these instruments, is like, what does valid mean? Somebody should be able to explain that to you. You know, the other thing is that when we talk about clinical judgment, and Dan and I differ a little bit in this regard, in that I'm probably really extreme in my loathing of clinical judgment. And I will say unstructured clinical judgment, right? The whole like, well, your left pant leg was rolled up a little higher than your right, and so I think that you have some issue with blah, blah, blah. You know, like we're wizards or something, as psychologists are portrayed on TV, that we can see inside your mind. We aren't any better at that than anybody else, and that's well documented since at least 1954. So there are lots of ways in which that clinical judgment reduces the accuracy of the predictions that we're making. The reasons why the structured professional judgment instruments are good, in my opinion, is not necessarily because they allow for clinical judgment, but because they account for more variables. And in fact, if you look at them, the variables that they measure, for example, coming back to the savory, if you go to the manual, it's really clearly defined what warrants a low, moderate, or high rating on a given item. And so what we find is when clinical judgment intrudes, people they stop looking at those criteria for the low, moderate, high rating, and they just look at the item and figure they probably remember what was in the manual and have like a gut feeling about it. Ah, yeah, I think that's high. You know, well, no, read the manual. Why aren't you reading the manual? Well, I know this one. Well, no, you don't, because you made an error here. So that's when the clinical judgment intrudes too, is when people have prototypes in mind. They're not using the actual criteria to score these things. And that becomes a problem when people are using structured professional judgment instruments, or even some of the actuarials, but they're not doing the legwork to find out if they're actually scoring these things correctly. And so the instruments become just a means to an end, right? The evaluator has already decided what their opinion of this child is. Ah, this is a high-risk kid. So now everything else becomes cherry-picked. I'm going to choose this thing, I'm going to lean this way, in service of coming to an opinion that they already had from the start. And again, that's why there's this need for transparency in how do we score these instruments, why did we choose the instrument that we used, how are we accurately communicating the results of the instrument to the attorneys, to the courts. That all becomes extremely important. Particularly in the case of risk assessment, these are extremely high stakes as far as what I often see, the stock that the judges, for example, are putting in what we're saying, and then the consequences to these children who might be civilly committed till they're 21 years old.
I'm going to follow up a little bit, because one of my big worries, and it's something that you all helped me connect the dots on, is we know that when a low-risk kid is put with interventions that are overbearing or not necessary, or put with medium or higher risk kids, it tends to turn that low risk kid into a high risk kid, right? And then on the back end, we're validating and saying, oh, we got that right, because clearly that kid that we misidentified as high risk, who was really low risk, reoffended because of our actions. So how does kind of the misuse of tools lead to the possible of compounding of this notion of prejudice and paternalism in our tools, or kind of working backwards from what we want to see happen rather than actually using the tool?
Yeah. Well, so you've touched on this idea of what we call contagion effects or iatrogenic effects. You know, kids placed into a deeper end than they need to be, kind of learning to swim in that deeper end, right? And then they do end up looking more problematic as they go on. I'm leery of like pinning all of that on risk instruments, because I think it happens through a number of systemic factors. And some of these are pressures that shape not only how we use risk instruments, but everyone else. You know, Dr. Boyd and I talk a lot about this particular pressure for evaluators that I think is there for juvenile probation officers and prosecutors and many, many others. And that's the pressure that you can easily imagine being the one who got it wrong and said a kid was low risk and they went out and did something bad. It's really hard to imagine getting it wrong the other way, right? If I say somebody's high risk and they go to a deep end facility, rarely does anyone come back and say, you know, you really got that wrong. You really kind of messed them up there. That's okay, right? That goes on. And in fact, maybe I look right because they think, who knows what would have happened, you know, if he'd been like let out. But it's very, very easy for people to imagine the opposite. There's these systematic pressures. I use this example often. I talk to the director of a juvenile justice system programming for juvenile sex offenders. Many of you know there's remarkably low rates of sexual reoffense. This state in particular kept great track of their data, amazing job. And they could tell you that the reoffense rate was about 5% for juvenile sex offenders. And the director of this program said, I cannot get any of my staff to call any kid low risk, no matter what. They're always moderate or high. Nobody wants to be the one who said low risk, and God forbid something happen. But that's a lot of error, right? So there is that pressure there, and things can really kind of become self-fulfilling prophecies.
Great. So we've talked about kind of the way that racial elements, or both implicit bias and explicit bias, can end up being baked instruments. We've talked about the way that the administrators of the tools themselves and their implicit bias and their explicit bias can impact the way the tool actually results. And then we've talked about this recognition and that there's a risk aversion to erring on the side of low risk versus erring on the side of high risk. Risk assessments in many ways have been put forth as this almost silver bullet to really help us eliminate a lot of the racial bias that we've seen in the system. What do you all see as the solutions to continuing to push forward to this goal of eliminating racial bias, either through the use of risk assessments or through other tools?
Well, so to quote our opening speaker, there are no easy answers, right? There's no simple solutions. Anybody who says there is lying. So I'll proceed to give a messy, complicated, rambling response, right? One is I don't think we have found clear flaws in these methods. I don't think that's reason to abandon them, right? We don't want to jump back to saying, well, subjectivity is good, right? Let's just be subjective and not be tainted by those instruments. Sort of like my metaphor with the bubble suit for toxins. That may still protect us from the biggest piece of toxins, right? The biggest chunks of debris, even if the fabric itself is actually still tainted and we're breathing in fumes, right? So I don't think we need to abandon this idea of risk assessment instruments because I think the alternative is worse. I do think part of the solution lies in being very studious and skeptical consumers of these. Both at the levels of the test, right? Know your jurisdiction, know what they're using, look into the research on that, really dig in. If you can't understand it or follow it, get somebody who can, work with somebody who can. And then at the level of individual usage and individual evaluators, really be skeptical of people like us, right? So if we say something, kick the tires. Like, look at how we scored items, look at what instruments we used and why. Really walk through with a critical eye. Don't think, oh, this is another discipline, I just have to trust these folks. Get somebody from that discipline. We both spend a lot of time doing kind of reviewing and consulting of other work. And more we have both made it policies to say, no, we're not just looking at the evaluator's report. We're not even just looking at score sheets. We want all the original data, because when you really backtrack through this, you find so many decision points that were subjective where you really could have gone another way. Maybe some of it's just difference of opinion, but some's clearly right or wrong. And by and large, in my view, these errors do tilt towards the level of finding kids of color higher risk. I mean, that's just the way people err in our system.
Dr. Boyd?
So I agree. I don't think we can advocate for abandoning the idea that we should have what amounts to a mechanical rather than unstructured approach to assessing this. But I do there's a group of researchers, Gina Vincent and colleagues, who are doing studies, and they talk about, what are they calling, risk need assessment. So framing it instead as, we're not identifying if this kid is high or low risk, we're identifying this child's needs and the intensity of services that they need. So I think some of it is language, but obviously that's not a solution, but the language influences how we're thinking about these things, and conceptualizing of risk assessment, instead of putting a child in a category, but rather as identifying the child's intervention needs, is a better way of approaching it, and having structured approaches to that, which then also promotes transparency, critique and evaluation, and better understanding by all parties. is I think the direction that we need to be moving in. I think we need to remember that there are lots of legitimate critiques to be made of the instruments, and we should continue to do that, but we also need to look at how the evaluators are using and scoring them, and we need increased transparency there. I personally think that evaluators and clinics should be, and these agencies should be able to report their data about what percentage of kids they're saying are high risk, what percentage of kids they're saying are moderate risk, what percentage of kids they're saying are low risk. Because if they're saying that 90% of their kids are high risk, when it should be much smaller than that according to just the frequency of reoffending, that alerts us that maybe we need to look at how this agency or this evaluator is doing things. Why is it that they're erring in this direction? And then I think, relatedly, we need to be thinking about what are we doing with the information from these risk assessments, because we often have this section at the end, recommendations. We take what we found in our evaluation and we make recommendations. And what we aren't doing a good job of doing is educating folks about what do we mean when we're talking about treatment, what works and what doesn't. You know, if you have a viral infection, you take an antibiotic, it's not going to do you very much good. But a lot of times people don't think of psychological interventions in that way. We figure, therapy, it's all the same. Well, it's not. And it certainly matters the intensity of the treatment, which too intense treatment can harm a child, can increase their risk of reoffending. And the type of treatment matters too. Substance abuse treatment now has good, strong documentation that it will reduce reoffense risk, but we're not seeing it provided to enough of these kids. They're talking about monitoring their substance use. They want them to drop. They want to do drug screens, but they're not talking about treating the substance use. The other thing that you don't see a lot of is people think, well, if some treatment is good, more must be better, so residential treatment must be the best. When in fact, there really isn't any evidence at all that residential treatment has any advantages at all over community-based treatment, which is where these kids are going to have to learn to function ultimately anyway. I get excited about that. I get very excited about that because I do think that's what you're saying is everybody thinks we're erring on the safe side to say a child is high risk. Everybody thinks we're erring on the safe side to say civilly commit them, send them to residential treatment. But what we're doing is we're separating them from their families. We're separating them from their opportunity to learn job skills, to finish school, all these things that actually do relate to decreasing their risk of reoffending. We're getting in the way of that with residential treatment. But it sounds good. It sounds good we're going to send them to this special facility. But then we're sending so many kids to these facilities that they're filling up. And now we're sending kids, not only are we separating from their families to send them to a residential facility, but we're sending them to one in Texas, or we're sending them to one in Florida, or some other place that, particularly for low-income families, it is impossible for their families to come see them. And so I think we also need to not only be thinking about the process of the risk assessment, but the recommendation section too. Doing a good job of making sure evaluators know what the community-based services are in the area, what the child is going to be eligible for, making sure that the court is also aware of those things, because otherwise what I'm seeing over and over is this idea that we are erring on the safe side to say a child's high risk, that we are erring on the safe side to say they need intensive residential treatment, when in fact that is not the safe side at all, not only for that child, but in terms of community safety, because we're ultimately, if we're talking about violence risk, we're talking about more victims now. And I think that's something that everybody can get behind, is we don't want more victims. Whether we're talking about victimization of this juvenile defendant or folks in the community, what we should be focusing on is what is the evidence base for what reduces reoffending. And as a potential resource for folks, I do encourage you to look at the Pathways to Desistance study, which is really focused on of this big group of kids who they followed, who were the ones who were able to desist, and what kinds of things seem to facilitate that, what kinds of changes and interventions within the kids seem to make a difference. And I think that also points us in a positive direction in terms of interventions to look at, again, rather than just going back to this dangerousness model where we slap a label on a kid or put a kid in a category and then send them away somewhere.
Thank you very much. And I want to thank you both so much for joining us today. I could talk to both of you all for hours, and you all may be getting phone calls from me. We do want to open up to questions, but I would like to give you each 30 seconds quickly. If someone fell asleep, which I doubt, or the food coma, it's the afternoon, or they're just tuning in on the live stream, what one tidbit would you like to make sure they take away from today?
Again, be skeptical consumers. not just of the instruments, but how they're employed, really kick the tires, I think is one of our themes.
Transparency and accountability for evaluators.
Thank you. Open up to questions. Sure.
So those valuations are from, have to be for particular things.
So then the question relates to how is cultural competency related to both maybe the instruments themselves and the administration of the instruments?
Sure. It's important. Yeah, I think you'll hear me hesitate because I think sometimes cultural competence gets thrown out as a real quick and easy solution. Like if you take the cultural competence class, then you're good to go. One of our speakers this morning talked about life experiences having a tremendous effect. We, as a field, are not particularly diverse, honestly. I went to a great graduate program, but still my best, most relevant experiences were working in the housing projects of Houston the year before that, growing up connected to the foster care system. These are probably, I'm sure I'm so blind to so much, but the times when I feel like maybe I'm less so, it's more because of that than because of any class. So cultural competence is important. We try to do that, but I would never want somebody to think like, to be able to say, oh, I took the class, I'm good, right? No bias in my stuff. But as a starting point, absolutely. As something that should be prioritized in our curricula, absolutely.
Right, I think, and I've heard the term cultural humility used before too, so the idea of competency is like this thing you can attain, you get a certificate and you put it in the wall, and anybody accuses you of anything, you say, I took the class, I'm fine. Whereas the humility process is the awareness that you don't know what somebody else's lived experience is like, and the willingness to accept their subjective account of it with some confidence, a willingness to be open to that rather than to say, well, I read about where you're from in a book, and so I don't need to ask you, I don't need to listen. So I do like the humility angle too, where there is a focus on listening, but again, I don't know, and I think Dr. Murray has a good point that there is an experiential aspect of this. You cannot just read about it, you cannot just take a class in it, and it needs to be an experience where you are connected to people and hearing more about their stories rather than in this evaluator-evaluee role, which is really clearly defined, and there's a major power differential. Because unfortunately, a lot of times what I see evaluators doing, particularly newer evaluators, is assuming that the way that the juvenile, that the kid related to them during their interview of them before they were adjudicated of a serious charge where they asked the kid a bunch of questions aimed at getting them to incriminate themselves, that during that interview, that's pretty representative of probably how the kid is with everybody. And they don't talk very much, so they must just be a deceptive, sneaky kid. They wouldn't answer these questions. They told me their lawyer said not to talk, so I think this kid is a big lying liar pants who lies all the time. And so, I mean, I say this, but I have seen it in reports where they're overgeneralizing how the child related to them in this very high pressure, high stakes context to say this is probably how this child is all the time. And that's why I think one of the items that we look at is personality. So we're looking at, can the kid demonstrate empathy? Do they care about other people? They have sense of responsibility and so forth. And that's where we have the least good reliability between two different evaluators. We walk away with completely different impressions. But then we still generalize that to say, well, that's how this kid is across environments. So I think there needs to be less confidence, again, in that unstructured clinical judgment of what I saw in that moment and how the kid relates to me must be just how this child is, and not taking into account the differences, for example, between myself and the child that I'm evaluating and how that might be playing into why the child is responding or not to me, and not loading that up with too much of saying that the reason for that is located within this child and represents some broad quality of personality style that's going to be there forever. Because that gets particularly damning when you see these reports that they're talking about a child being psychopathic and having no remorse and no empathy, and it's based on kid didn't admit to the offense when you asked him about it. What? Doesn't, you know, it's not right. That's not how we're taught to assess it, but also that's massively problematic from, you know, this cultural humility point of view, I think.
Great. I want to thank you both very much. Appreciate it. Round of applause.
Too excited.
Thank you so much, Dr. I'm about to call you Dr. Ferrer, all these doctors up here, but Professor Ferrer and Dr. Boyd and Dr. Murray, for really helping us understand how risk assessment instruments and other forensic instruments might be designed and implemented in ways that are harmful to children of color and that undermine public safety. I think that's really important, so thank you all very much. And do a quick change here. And I know I've seen our Attorney General's in the room. I assume he's making his way to the front. Oh, there you are. Yeah, excellent. So thank you all for sticking it out. This has been a long day, but hopefully it's been an informative day. I certainly have learned a lot, so I thank you very much. Our final discussion of the day, as they're setting up, involves alternatives to systems involvement. I often refer to prosecutors as gatekeepers of the juvenile and criminal justice system, and so I am very honored to have Carl Racine, who here with us today, who I see as a real gatekeeper, as a person who really understands that gatekeeping function. So we're going to hear from our Attorney General for the District of Columbia for a 15-minute talk about prosecutors as change agents, and we're going to have the rest of the sort of panelists come down to the front for a fireside chat that will be moderated by Mary Ann Scally. So if we'll all give Attorney General Carl Racine a round of applause.
You want me to come up there while I was going to stay?
Yeah, you know. It helps us with our transition. But you can stand wherever you like or here.
I'll stand.
Oh, stand out here. Excellent. Beautiful. And then if that's the case, I'm going to give you a...
Okay. Thank you. So let's see. Yeah, good. Okay. Am I on? Do we know? Yeah, you're good. I'm good? Okay. Okay. If I could, first of all, let me acknowledge that I've never done anything close to a TED Talk. And so I don't have my TED Talk gear, which would normally be, I guess, either a turtleneck or open collar shirt or something of that sort. I'm not making fun of the TED Talk thing. I know my brother's going to get upset here. He's got the most TED Talk hits for good reason. Adam is an extraordinary speaker, really, because not only he's practiced, but he speaks from the heart, and he's, you know, very empathetic, of course. So if you haven't seen Adam's TED Talk, I really do commend that. You still getting paid on that?
Sure, yeah.
Yeah, okay, very good. So look, this is going to be, I think, the last session almost of the day. Why don't we all do one thing before I get started? That is stand and stretch for just a second or so. Because I ain't into having people falling asleep when I'm talking. Okay, yep, so we just stretch a little bit. You know, left, right, there you go. All right. All right. All right, enough already. Sit down.
Should you move?
Very good.
Carl's been moved over to.
And then as soon as we are technologically ready, we're good to go. What's up? Cool. Okay. So I was listening to the presentation earlier, and I was struck by what Dr. Sarah Boyd said. And I just want to start off with a quote that clearly related to one of her comments about what we as a society and government are willing to spend money on and what we are not willing to spend money on. No one other than Marian Wright Edelman said the following: we're willing to spend the least amount of money to keep a kid at home, more to put him or her in a foster home, and the most to institutionalize him or her. You know, just something as basic as that, and we do it reflexively without any idea of whether it works. And if you look at whether it works, the answer, of course, is that we're misspending money and getting awful, awful outcomes. So let me first start by saying thank you very much to Chris Henning and the entire team at the Georgetown Juvenile Justice Institute. I've known Chris for years as a former public defender, never as an accomplished trial lawyer as Chris Henning was, but I have so much respect for Chris. In fact, I'll share a little bit of a privileged conversation that we had. You don't know what's coming. You know, we lost a leader in our office, Tamar Meekins, who is the head of our public safety division at the Office of Attorney General. I'll touch on this a little bit later once I get going on the presentation. And I reached out to Chris, and I asked Chris whether she might consider applying for the job, Wally. I know you're getting upset that I even asked. Okay. And Chris was very, very clear and crisp, as she always is. You know, gotta love people who are focused and understand kind of their purpose in life at any given point. She, you know, very politely and immediately responded by saying, "Hey, Carl, I'm flattered, but I gotta tell you, not yet. I've got much more to do." And let me tell you something, obviously, she, yeah, we're talking about one of America's you know, greatest thinkers and doers on issues related to criminal justice generally, and of course specifically in the area of juvenile justice. And when you said that to me, I must say that I was elated, because I know that when you say you have more to do, I know that means that tomorrow, the future, as long as Chris Henning and Georgetown is here, is going to mean much better things for our kids. So it's a really a pleasure to be here. I want to acknowledge first my Office of Attorney General colleagues. There are many. I sure hope that you charge here, because you did well today. OAG people, put your hands up, please. Look at that. There you go. And the head of our juvenile justice team there, Santa Sonnenberg in the back, and Alicia Washington is the interim public safety division chair. And I'll just point out Seema Gajwani, who is the special counsel in charge of juvenile justice reform at the Office of Attorney General. We also have new employees. I think most of them are up there in the galley. These are 4 new employees that we have. Is it 3 or 4, Seema? 3 new employees that we have who we fought for in the budget season. So hard to get money for good programs. It's ridiculous from the government, but we fought for these folks, and what they're going to do is they're going to really get out there in the community and practice restorative justice. So put your hand up. We're thrilled to have you. Bingo. And the 4th hand there is a gentleman, Keneal Cole, who has a story to tell. He won't tell it here, but his story is already out there in the internet world. Keneal, can I just give him 20 seconds on you? Briefly, you know, Keneal himself was detained and locked up as a youth, decided to do different things with his life. He's experienced violence, seen it, not only within family, but also friends and neighborhood, devoted his life while being committed to DYRS to education and putting his mind in a positive framework. Absolutely went out aggressively to solicit mentorships. Let me just say that DYRS is reflected here, at least in one individual. Anybody else from DYRS? Don't believe the hype when people criticize DYRS as being careless, heartless, etc. There are people at DYRS who do an extraordinary job, and they have remained with Keneal Cole not only throughout his tenure at DYRS, but after DYRS. And I'm proud to say that Keneal was the first summer intern at the Independent Office of Attorney General, did such a good job that after 2 days of work, we decided to pay him. We normally don't pay our interns. We asked him to come back and work last summer, so a 2-summer time intern, and we just hired Keneal, who graduated this past Saturday from Delaware State University. And I'm sure he'll tell me later that I missed something juicy, but all good. So let me get on to my presentation. I'll try to whiz through this and be real quick. So what I'm going to do really is just briefly give you a little bit of personal background, because that kind of shapes where my philosophy is. Number one. Number two, I'll tell you a little bit about what we've been doing at the Office of Attorney General. We have been independent for roughly, call it 26, 27 months. And of course, we've sought to have a huge impact by hiring Seema, Tamar, Santa, and a whole bunch of other folks, and having a great staff who have frankly hung in there with a culture change at the office to have a positive impact on young people. And then I'll talk a little bit about sort of what's next. And you see a little bit of what's next. People that we hired. And recently, I guess it was just last week, my team and I penned a piece in the Washington Post really going towards how to reduce violence in the District of Columbia and what we can do to treat our young people who we know are suffering from trauma. Left unattended, what's going to happen? They're going to walk right into the abuse and neglect line, walk right into our office, and then God knows what happens from there. Okay? So those are the 3 areas that I want to talk about. Let's go real quickly. Who am I? I'm a guy that doesn't know how to use a clicker. I am that man.
Try pointing down there, Carl.
Which one?
Try pointing it right down there at that screen.
Oh, that's my man Ted.
Gotcha.
Right.
Still not working.
Might be frozen. See, it's not you.
Okay, cool.
Can I say to the AV team that the computer's frozen?
Oh boy.
There we go.
Cool.
There you go. Try again. There
Bingo. Okay, so who am I? Real quickly. My family comes from Haiti. Let's see, I was born in late 1962. There was a rough time in Haiti. The then dictator, Papa Doc Duvalier, doing a lot of bad stuff. So my parents decided that they wanted their kids to live in a free society where they could at least voice dissent and have an opportunity to be, fully free individuals who would not only fall in love with their new country, but also remain tied and be supportive of Haiti. We landed here in Washington, D.C. because my mom went to Georgetown to get her PhD in foreign languages and linguistics, moved around for 3.5 years. In fact, my mom and dad didn't send for my sister and I until 3 years after they were here. My mom and dad left when I was 6 months old. They finally settled, and we bought a house in Ward 3. There was a great presentation, I guess the first presentation here, that we're all criminals, right? I can tell you that I'm a criminal, and I didn't get arrested a lot because I was around Ward 3, okay? Look, that's where I grew up. We were very fortunate to go to Mergedale, Wilson, and graduate from St. John's High School. No doubt that zip code helped me out a ton. Look, I learned early on in public school that the fact that I was the son of my parents and the fact of where I lived and all of the other social supports, and I played a lot of sports, meant that my chances of success were dramatically better than kids who I played with. I also learned very early on that the kids who I played with and went to school with were every bit as talented as I was on the court and in the classroom, but I also understood that chances for them, were going to be harder. It was going to be harder for them to break through than for me. Fundamentally, of course, that is completely and totally unfair, and isn't that what a government is for? To try as best they can to kind of equalize or boost opportunity for those who come from more unfortunate circumstances. Started off my career at a law firm, wanted to pay my student loans, right? Just like a lot of other folks here. Did that in 3 years. The most consequential experience I had at a law firm was that I represented a gentleman named Timothy Bunch, who was on death row in Virginia. We lost our federal habeas at the federal district court level in Richmond, lost before the Fourth Circuit in a 2-to-1 decision, lost rehearing en banc. It was something like 7-6, all on party lines, Republican, Democrats. Judge, my client Tim Bunch was executed. I'll never forget the conversation I had with Tim the first time I met him. Tim said to me, hey, you know, I got to tell you, I think you're a really, really nice young man and you're very smart. He says, if I'm you, this is what I do. After this case, because I want you on my case until the end, you should become a prosecutor. I said, why the hell would I be a prosecutor? He said, because if you're a prosecutor, you can help many, many more people than the single people that defense lawyers like you are helping. I completely disagreed with Tim, so I entered the public defender service after we moved on in our relationship. And I learned a ton there. As I said, I wasn't so good, actually, as a trial lawyer because as a juvenile lawyer, I got real lucky one day. A great judge named Mildred Edwards appointed me to a case that was a hard case. It was an assault with intent to kill case where my client clearly, as the evidence demonstrated, was trying to kill someone and shot a lot of times. But you know, the equipment wasn't so good, nor was his eyesight. And so I asked her, I said, you know, Your Honor, why are you putting me on this case? She told me that she's putting me on the case because in a prior case, it's like a UUV case, stolen car case, I had drafted something called a Rule 48 motion where I asked the judge to stop the prosecution, dismiss the case, because we came up with a program for the kid that accomplished all the goals of the juvenile justice system, rehabilitation. And she had granted that motion. She said, my goodness, you draft one hell of a Rule 48 motion. I suspect you might be able to come up with something similar for this particular kid. And sure enough, we did, and we got the government to not fight us on it. And I know that the kid is doing really, he's no longer a kid. He's a man, and he's doing quite well in D.C. today. The point is that for whatever reason, I saw early on that the right level of services given to a young person could absolutely help that young person get him or herself in the right direction. Okay, yep, ran for office, that's a trip, and whatnot. But the whole point of this is that we grabbed the juvenile justice issue, right? DC is such a peculiar jurisdiction that we have, it's rare that we have exclusive authority over stuff. No exclusive authority on our budget, no exclusive authority with respect to the drafting of our legislation, right? Can be overruled by Congress. But for some reason, we have exclusive jurisdiction, the Office of Attorney General, over juvenile justice. What did we do then? We decided to really focus hard, analyze the system, and see what improvements we could make from what my client said, the perspective of a prosecutor. He could have a huge impact in that realm. What did we do? Basically, three things that we did to, I think, with humility, change the tone in the District of Columbia and hopefully have a positive impact on juvenile justice. First thing we did was we absolutely set the tone at the top with respect to leadership. Why I called Chris is because Chris is the person who was our leader. Tamar Meekins, she's the beautiful woman on the right, was not only brilliant, a great trial lawyer, a really awesome academic, but she had more compassion and empathy than anyone I had ever met. And so Tamar came in, and we determined that we would change the definition of success. I don't want to be overly critical of the prior leadership in terms of the sort of public safety division or juvenile justice section at OAG. I just don't think that they really prioritized juvenile justice and even really thought about what juvenile justice reform might look like, and that's not a criticism, it's just the way it was. We were going to do things differently. So our definition of success was going to be not only how many percentage, what's the percentage of cases you're papering, how many convictions you get, how long is the sentence, but instead, are we actually having an impact on public safety by reducing the rate of recidivism? Are we being true to the second function, or indeed the primary function, of the juvenile justice system, which is rehabilitation? So, change that definition of success. We also changed the rhetoric around public safety from being tough on crime to being smart on crime. I can't overestimate, really, and can't overstate the reliance on my fabulous team. Now, gatekeeper. I didn't know that language, to be honest with you, until we met with Chris and Seema and we started figuring out what we could do with the Office of Attorney General. They taught me that as the gatekeeper, we had a huge opportunity to actually divert young people away from the criminal justice system. Why would you ever want to do that? You want to do that because the outcomes were not successful outcomes. So what we did was we did a review, and it was a rough review, kind of imprecise because we still have poor record keeping in the District of Columbia relative to what the probation services people do at the court social services, as well as DYRS, although DYRS is doing a much better job these days in regards to record keeping. Roughly speaking, what we found is that the recidivism rate for kids who went through probation was well over 50%, and the same was true for kids who went through DYRS. We had a novel concept, and we found a great friend in Hillary Cairns, who is here. Raise your hand, Hillary. I know you hate it when I do it. There you go, Hillary Cairns, who runs the ACE diversion program from the Department of Human Services. I think right about that time, you had started up, what, in May 2014 or so? About $370,000. You had 3 FTEs. Not so sure how many clients you had, but you had a great program and a committed leader. So we got together with Hillary and we said to Hillary, hey, look, we're going to start diverting a whole bunch of kids to your program, and darn it, we're going to overload you. So you need to keep us surprised as to your resources, what you need. We'll try as best we can to get you more resources. Fast forward, you see the numbers up there. So about 993, almost 1,000 kids have completed the ACE program. Look at that. The percentage of youth who are prosecuted for a crime after completion of ACE, 11%. 80% of the kids who've completed a program, the ACE program, have not been rearrested. That's a low standard, okay? It's easy to get rearrested out here, right? Okay? So obviously what Hillary and her team do are just amazing things, and I'll just go briefly into what they do. I do commend you to reach out to Hillary if you're interested in understanding in a more granular way how ACE works. But to make a long story short, we do use an assessment tool. It's the CAFAS assessment tool. The CAFAS assessment tool, essentially, in my words, tries to measure anxiety, stress, etc., stuff that really impairs cognitive thinking and an ability to make calm and rational decisions. After all, we're talking about kids. When their CAFAS scores are up, they're more irrational and impulsive than they are just by their nature. The number 80 is a big number for CAFAS because at 80, a kid can qualify for intensive behavioral health services. If I'm not mistaken, Hillary, the average kid that goes through ACE has a CAFAS assessment of 111. Is that too high? Is what? 88. 80. So above that 80 threshold. All right. After the assessment, Hillary's team literally gathers around in a conference room, and for my money, it is the most effective conference room in government today. They review the CAFAS score, they review the kid, they've already done their due diligence, get to know the young person, get to know the young person's family, coach, teacher, anyone who cares about the kid, and then goes about fashioning a suite of services around the kid to encourage the young person to become more resilient, be excited about life, and start believing in their own future. Here's an example of a young guy, Swindell, right, who really thrived in art therapy, right? Successfully completed ACE, and that's a high school graduation picture there. I'll tell you another little thing. When you see kids through ACE, who graduate from ACE, or kids who go through other programs, and they go through ceremonies like this with an auditorium, it is an extraordinary experience to see a kid hear his name or her name being recognized, have somebody in their family yell out, "You go, Swindell!" Right? For the first time in that kid's life, feeling like, damn it, you know what? The future is mine, right? We need to celebrate our kids much more than we do. It doesn't even cost any money to celebrate a kid. All right, so let's go back. More sort of technical stuff. You know, by the way, through the ACE program, successful completion also means a positive impact on attendance in school. That's not our primary objective, right? But it makes sense that if a kid really takes to ACE, gets the right services, they're more inclined to stay in school and do better. Look at that. The CAFA score improvement, is that pretty stunning? 91% of the kids who complete, right? Guess what? They leave with less anxiety. That means that they're more apt to make good decisions about who they're spending their time with, right? When to make a decision to say no, not going to that party, not going to that park, not going to Gallery Place, right? Because bad things happen. That's as a result, again, of real good services. And the services are imbued with love. All right, we move on. What's next for us? We're focused, as I said, on reducing violence and then really trying to get the city to put its arms and its wallet around treating kids. Washington Post editorial of about 2 or 3 weeks ago, shocking editorial. The nation's capital where children live in fear. All these cranes out here, a lot of construction around Georgetown, gives you the indication that D.C. is thriving extraordinarily well. And certainly from the measure of growth and development and revenues, tax money and all that stuff, population influx, D.C. is doing well. But I'm here to tell you, as you know, that D.C. is absolutely failing its young people, particularly young people in the most underserved and under-resourced areas in town. And I just don't think that we can tolerate that level of complacency anymore. The feature on this article that the Post did a couple weeks ago is of a kid named Tyshawn McFadder at 8 years old who essentially witnessed in a form the death of his father. In the prior 3 weeks leading up to the death of his father, many, many, many other neighborhood kids witnessed, saw, were the victims of violence, including murders. This obviously has an extraordinarily negative impact on a kid. Untreated, what do you think is going to happen to Tyshawn? Feature in the Post, one day, 3 weeks later, what are the articles about? A $12,000 a month apartment in Shaw, right? This is a values issue. I mean, we got to really make the elected officials put their money where their mouth is when they say they care about young people. Okay. I'll just move really quickly now. Everybody here, I know I'm preaching to the choir. I'd love to have a naysayer in the audience for a debate, but I know they're not here. Again, we got to focus on the trauma. You know, these young people are absolutely living in a state where they're apt to make awful decisions because they haven't built up the resilience, don't have the experience in positive activities, and frankly, you know, don't really have any sense of measurable hope for the future. We can do it by expanding ACE and going out before even kids come into the criminal justice system. All right, I'll go real quickly here. We drafted an op-ed of the Washington Post, I guess it was this past Friday, and published this Sunday. And there we propose that Washington, D.C. adopt the cure violence model. I'm happy to make these available to you. I'm not going to go into what the cure violence model is since I'm going a little too long. We also advocate in favor of a program called Triple P, all about parenting skills for young parents. and even older ones. And then lastly, you know, we advocate for more programs like ACE, and we're advocating for the cloning of Hillary Karens. Not going to talk about that, but look at this cure violence model where it's been employed well, you know, with smart people who are recording the data. You've got extraordinary drops in crime, and a very important aspect of cure violence is the whole idea of resetting community norms to make sure that the community speaks when violence occurs. This shit is not acceptable. Sorry to use that language. This is PDS language. Just totally, totally unacceptable. All right. Fundamentally, we at OAG believe that we can and must do better by our children, and I know you share that vision. Thank you.
Thank you so much, Attorney General Racine. So, first of all, I just want to thank Georgetown again for hosting this symposium for us today, and what a magnificent conversation it has been. So I am delighted to be here as the moderator of the final panel, where we're really going to wrap up all the themes of the day by talking about creative solutions to addressing racism in our juvenile justice system. So James Bell started the day by talking about the structural context of racism. And he talked about the fact that the structural context is built on the idea that we all want to feel safe. And it's also built on fears. So we've created laws that are implemented in a way that creates structural racism that's impacting our children. So what are the creative solutions we've heard about today? We've heard about creating standards, policies, training, using risk assessment tools, the reasonable black child standard. And now we're going to talk about concrete ways that we can keep children from penetrating the system. And I'm happy to be here today with Adam Foss, who started a program that we're going to hear a little bit about as a former prosecutor. We heard from him earlier. Dr. Lauren Abramson, who works in a program in Baltimore that she's going to talk about with us, and we'll hear a little bit more from Attorney General Racine. So I'm going to start with Adam and just ask you to talk to us a little bit about your new program that you've started, and specifically about how it impacts youth.
Sure. First, can I just ask how many prosecutors are still in the room? All right.
Carlsville office.
Wonderful. How many active defenders, either bar advocates or public defenders, are still here? Okay, good. How many of you are from DC? Great. All right. This room should be full of people because like one side or the other is not going to fix these problems. And what drives me nuts about these conferences is depending on whose name is on the banner dictates who comes and who doesn't. And if we're really serious about doing justice for our kids, which we all walk around and say that we are, then we need to be coming and talking to each other about these things. Like, not one side or the other is not going to fix it. I'm going to try, though, by running my new program, which, so it was crazy to me as a new prosecutor that I literally knew nothing about prosecuting. And what was more concerning to me was how the metrics were sort of aligned in our office, right? You wanted to get to be the head homicide prosecutor so you could try 3 cases a year and win them. And in the meanwhile, if you're a brand new prosecutor, you're either in juvenile court, you're in district court, churning through thousands and thousands of cases, making thousands of decisions that are impacting people's lives. And our resources and our value was ascribed to those higher level people who really, when you talk about impacting the community, was marginal. And there was no support, training, or resources put into those of us who were on the line every day, particularly those working in juvenile court. And the damage that was being done every single day, not because we were bad people going in the job, none of the people that you see in here who are from the AG's office are bad people. I know that we have this like tension between us, but there's a core value that we all share, I'll say it again, and none of the people that I was standing around were bad people. We were given this tool, we were asked to go into a community, fix community problems, and we were given like a rubber mallet. And that was it. We were just given jail or no jail. Not once did anybody talk to us about what adolescent brain development was and how that could actually help us as prosecutors intervene in behavior. We thought to ourselves that 48 hours in a jail cell was teaching a kid a lesson, not understanding how detrimental that could be. We used to laugh about the shackling of kids in courtrooms, and sort of just like it was just something that happened because the judge who was sitting on the bench didn't really care about what that meant to children. And you wouldn't send your kids to a doctor that didn't know things about kids. It would be negligent of you to do that. And the same, we should have the same sort of mentality about who is watching over our kids in the criminal justice system. If my job is to do justice and another lawyer's job is to represent the best interests of the child, then we should be working together, not an adversarial system. My program is aimed at teaching prosecutors before they start going out on the line and making these really bad decisions, all of the things that we should have learned in law school to become lawyers, but we didn't, including the academic sort of subjects like adolescent brain development, trauma, poverty, the intersection of those things, restorative justice, alternatives to incarceration in the community, but also experiential learning. So let's go actually meet some young black kids before you actually meet them in a courtroom. Let's go to an after-school program. Let's go to their school so you can see what the environment is like in their school. Let's go to their apartment and see what it's like to live in this apartment. Let's ride on the bus that they take from starting at their house, and they have to get on 3 more and then the subway to get to school. So that when parents come in and saying, yeah, he's late for school every day, da, 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 you can kind of have an understanding of where you're at. Did you have a question back there? No. Oh, I thought I saw you raise your hand. Okay. That's the bottom line. The fact that we don't have something like that, and that we have young people with this really, really vast amount of discretion who don't know what they're talking about, but really want to be, is something that we as advocates on whatever side of the equation you're on, is something that we just cannot have exist anymore. And that's what I'm trying to do now.
So the name of your program is called Prosecutor Impact. And we know that when your prosecutors are making decisions about young people, I'm actually going to put this to you and to AG Racine, what are some of the factors that prosecutors, be they young or old, consider when they're determining whether or not a child should be or could be diverted from the system?
What are we considering? The facts of the case in a criminal record is what we're considering. These 2 documents that are given to us, every prosecutor, that's what our toolbox is the facts of the police report, which of course are always 100% accurate and gospel, and the criminal record, which is the most useless piece of paper that we could generate in the court system. And then we're asked to use some like algorithm that, you know, is just sort of traditional to say, okay, this person is high risk because they have a bunch of defaults and violations of probation and guilty convictions, and the facts are really bad, and therefore this person is not eligible for diversion. We know nothing about the risk factors, the protective factors, or the resiliency of the kid that we're interfacing with.
And how do you think race impacts those decisions?
Again, so if my experience with a young person, even if I have more data, like let's say that some of the data points that I'm looking for are data points that are in a lot of risk assessment tools. What neighborhood do you come from? How's your school attendance? Are any of your parents incarcerated? How many times have you been previously arrested? Who are you hanging out with? These are things that often, you know, like maybe they're not explicitly looked at, but while we're reading police reports, like, oh, you were with Johnny too? Uh-oh. We are looking at those things to determine diversion, and if you come from a neighborhood where the police are never at, if both your parents are employed, your friends aren't anybody that we're familiar with, those are typically kids who aren't from my neighborhood, and therefore they're white. And the kids that I do know, who I've known for a while, who I know all their friends, and I know that they've been arrested, and I know that they have parents who are incarcerated, they're kids of color. And so just sort of the optics of diversion are racialized and unfair.
So what I love about this, what you're talking about, is that prosecutor impact is really going to try to help people, prosecutors specifically, experience more about the reality of our young people before and as they're making decisions about our young people.
Correct.
So that strategy can really help turn the whole decision-making process on its head.
Correct.
Attorney General Racine, so we heard about some of the strategies that you're using here in D.C., but can you talk a little bit about diversion decision-making specifically? So when things are papered in D.C., how are decisions made, and what are some things that we can do in D.C. to ensure that implicit racial bias, explicit bias is addressed as those decisions are made?
Sure. First, I look forward to engaging your services.
Yes, sir.
You know, we think we're doing a pretty good job, but we can always learn more, so consider that a deal.
Done.
Okay?
Send you a bill.
And everybody heard the discount that we negotiated as well? No, all good. So here's what we've done. We've tried to get away from the simple review of the nature of the offense, the age of the kid, and whatever else we see. Why do we try to move beyond that? We try to move beyond that because we've been actually building, right, a reservoir of good, hard data around the type of kids who are successful through diversion. And what we found is that kids can succeed in diversion even at the armed robbery level. And so it's less about, candidly speaking, it's less about the seriousness of the offense and more about what's going on with that young person, whether there are supports that are already in that young person's life, and whether those supports can be bolstered by the kinds of supports that the ACE program and other programs provide. I want to make 2 points. First, kids can get diverted even prior to coming to our office. The Metropolitan Police Department is able to divert kids. In that regard, we give them very strict guidance so as to, candidly eliminate variability and bias in decision making, knowing that at the end of the day, we're going to get a second chance to divert the kids who come to us. And so the police have a mandatory divert criteria where they have no choice but to divert if a set of factors is identified. The other thing, because we're relatively speaking a small office in a pretty small community, we have centralized the diversion decision making to the point where Chad Foster, is Chad here? That guy's doing diversion. Right? Chad, we have a single individual who mostly does the diversion decisions. And we try as best we can to support Chad when he needs to be supported. We get input, of course, from the other prosecutors. But I think that allows for greater consistency. And I just can't tell you how appreciative we are of his work. I think the last point I'll make is that there are other jurisdictions like Seattle that have taken diversion one step further, and they're actually diverting kids who've been involved in far more serious offenses than the norm for diversion. And I look forward to going out there. I'm going out there next month to visit and to learn and to try as best we can to bring some of that stuff back to the District of Columbia.
Wonderful.
So, can I make a comment on the racial piece? I know you're going to get that. Actually, no, I'll stop.
Okay. Thank you. So it's wonderful to hear about how prosecutor offices can really make an impact on ensuring children don't penetrate the system further and address racial bias. But now I want to actually pivot to another alternative and talk a little bit with Dr. Lauren Abramson, who's joined us from Baltimore and runs the Community Conferencing Center. And if you could talk to us a little bit about restorative justice programming, maybe define it a little bit for our audience, which it looks like is mostly prosecutors and defenders, but I'm assuming there are other stakeholders in the audience as well. And then share a little bit about how you get referrals for youth specifically, and how you think restorative justice can also help us address racism in the system. That's a lot.
Sure. Go. Okay. So my 30-second, I guess the quickest way to, how many people know what restorative justice is? Awesome. All right. So I'll give you the 20-second one. I think it's really, at its heart, it's about asking a different set of questions when somebody harms somebody else. Instead of in our retributive system, which asks who did it and how can we punish them? And what law was, well, I guess, who did it? What law was broken? Who did it? And how can we punish them? And what we're interested in with restorative justice is a very different set of questions. And those questions are, who's been affected by what happened? And how can we repair the harm and prevent it from happening again? A very different set of questions, and hopefully I'll get a chance to share a story to give you a sense of how things end up very differently when you ask a different set of questions. So just real quickly, the process we use, I learned about it from colleagues in Australia, which they adapted from the Maori, the indigenous people in New Zealand. And it's called community conferencing, which is one way of doing restorative justice. And what we do is there's a trained, neutral, or equally caring facilitator that brings together everybody who's been involved in and affected by the situation and their respective family members and supporters. And everybody sits in a circle. An average conference is between 12 and 20 people. Everybody sits in a circle and talks about 3 questions. Everybody hears what happened from the person or the people involved in causing that harm. The second question is everybody gets a chance to say how they were affected by what happened. And it is by design a very emotional process. Tissues are part of what we carry with us as facilitators. So everybody gets a chance to say how they were affected. People are really getting a chance to be human. And by the time we get to the last question, there's a very different feel in that circle. And the last question is, okay, having heard all this, what do you all want to do to repair the harm and prevent it from happening again? So these are the victims and the offenders and their family members all deciding for themselves how they're going to fix this and prevent it from happening again. If they can, they come up with a written agreement, and then we follow up with the agreements to see if they're abided by. I will hasten to say that in Baltimore, since 1998, 18,000 people have participated in a community conference where they have successfully resolved that conflict or crime. 95% of the cases result in a successful agreement with 60% lower reoffending at 1/10 the cost of what we're currently doing. So I like to say that we're indiscriminate about where we'll take referrals from. I really don't care. We get referrals from community members, from schools, from school police, city police, our juvenile justice system, our prosecutor's office, and anywhere else.
And who determines whether or not an incident goes to you or goes to the prosecutor's office?
I mean, we have sat down with each of our separate referral partners and we established what are the criteria that you want to use. Now, the tendency is to use this for first-time offenders, and our pushback is always like, you know, the research shows that if you don't do anything with most first-time offenders, they don't reoffend. Why do you want to spend your money and resources with those young people? Give us the 12-year-old with 10 priors, because whatever is being done is not affecting them from reoffending. So in Baltimore, 97% of the young people going through community conferencing are African American. So it's one of the programs that is actually working to keep young people of color out of the system, and we hope to get it as early as possible. And you know, the disparities of who ends up in that system, we all know the data. I mean, there was literally 1 week where we did a conference of 2 African American 14-year-olds who were arrested for stealing each a pack of M&Ms from a 7-Eleven. And that same week I found out about, in an affluent, predominantly white community, kids set a porch on fire and the police went and took them to their home.
So I was just about to ask you about what impact you think implicit racial bias has on your work. I think those examples may have explained it, but is there something a little bit more you want to say about that?
I'll leave it at that.
Okay. All right. So similarly, back to Adam Foss and Attorney General Racine, you know, we talk about implicit racial bias in our own offices, whether we're prosecutors, defenders, community stakeholders. What impact does it have on the work that we do, and what can we do as leaders to ensure that implicit racial bias is addressed in each of our daily work? So we'll start with Adam Foss.
I don't think that I have much more to add from what I said this morning, other than just like being constantly aware of it. It's not something that you can, you know, I was on, I worked in an office of 160 lawyers. There were 9 lawyers of color in a place that saw 99% of the people coming through were people of color. And the first time we had an implicit bias training was 2015. I had been there for 8 years. And I remember sitting in the room, and it was mandatory, it was over lunchtime, it was an hour long, and I remember sitting in the room and watching the people go through the training, and I was like, no, dude, you're the one that needs like this the most, and they're the most checked out. And it was infuriating because, you know, that the executive staff got to check the box and say we did it, but there was no implementation. It was sort of a joke, like people were joking around in the office. And it's just, you know, as leaders in the office, and I'm glad Carl said something about sort of people who, just because you're not in the executive suite doesn't make you a leader. Once you've been in the office like 6 months, you're a leader to the new people coming in. It's got to be a daily thing that you're talking about, either when you're screening cases in the morning, or it's something that honestly needs to be addressed all the time, because you don't need to be a genius to see what is happening. And to think that somehow stats are skewed, or this is a biased conversation, it's a political conversation, like, go home with that shit. This is the reality of where we're at. The DAs, somebody mentioned Chisholm earlier, for John Chisholm to say, I'm taking this data and I'm going to do something with it, is a very powerful thing. For another leader whose name will remain unsaid, who was also part of the Vera study, to continue to maintain that racial bias wasn't part of his office, it was somewhere else, you just shouldn't be the leader of this office anymore. We don't have time for that nonsense, because kids every single day's lives are getting ruined, and we're failing at our jobs for doing that.
Thank you. And so Attorney General Racine, similarly?
I would just add, pardon? Oh, okay. Thank you, sir. I would just add a couple things. Number one, under Tamara's leadership, every single one of our prosecutors went through implicit bias training. So the training matters a lot, and it's got to be done with some regularity. That's number one. Number two, the people who you actually have, not only as your leaders, I take your point really well, but on the line, who are also leaders, have to be in tune or be willing to make efforts to be in tune with the community. And what does that mean? It means they have to be willing to get outside of their box. This is why I love going to community events in the District of Columbia. Just last week we had an event was it Ward 1 on human sex trafficking, and there were at least 7 other OAG folks, many of the people here, at that event. And I wondered, are they there just to be supportive of their colleagues or me? But it's totally not about that. They were there, I think, to get more connected to the community. And so by having a culture where we're active and engaged in the community and we invite and encourage people to attend, you're more in line and more empathetic, I think, with what's really going on. Third, it's really important to make key hires. I'll note that one individual in our public safety division spent over 20 years in jail for voluntary manslaughter. He is probably one of the most impactful leaders in our office, just by virtue of how he now lives his life with the grace, humility, and what he's willing to do to mentor and guide people. That is a huge implicit bias training every single step of the day for that man is providing. I'll note that just, what was it, a couple weeks ago, we were at the DC Central Kitchen volunteering. That's another way of having implicit bias training. And so there are creative ways to build a culture that recognizes that left to our own devices, we're going to be biased, period.
And it's so important what Carl was saying, because it doesn't matter why folks were there. You know, like in our office, once in a while the DA would mandate community service. You know, like we'd have to go out in the community. And just by people being out there, they're like, oh, okay, these kids are just like me. And I understand. I started a reading program in an elementary school for prosecutors to come to. We started with 4, we ended with 40 prosecutors going to an elementary school every Wednesday morning. And it was because they were telling their other work colleagues, like, this is cool, right. It makes me feel good, and inherently you're getting implicit bias training because you're seeing 4, 5, 6-year-old black children, and you're like, these kids are just like my nieces and my nephews and my kids. And so rather than continuing to live this narrative that we have for since the beginning of time, thinking about how do we prosecute outside of this building that we created is, I think, the most powerful way to rid ourselves of implicit bias.
Can I just chime in on things? So I worked at a law firm back in the day, and I was fortunate enough to become the managing partner of that law firm. And I knew very well from kind of coming up the ranks and then coming back to that firm how hard it was for people of color and women to ascend to partnership and leadership. So we had a killer, call it inclusion, diversity, seminar. And it was an amazing experience where we had 100 of our people participate in this training, I'll call it, not a seminar. One of the training vehicles was remarkable. We were all given multiple colored beads, and we were also given transparent boxes. I don't know whether you're familiar with that training. How many people are familiar with that training? We were asked about 20 questions, and we were asked to, based on our answer, select which colored bead goes in your box. The questions were questions like this. You have been invited, mostly, well, you've been invited to the house of your colleagues. The colleagues who have invited you are of what race? Boom, to their home. How many people have invited a colleague to their home? You put the bead in. Your teachers, overwhelmingly in your life, have been, put the bead in, boom. The music you listen to is, generally speaking, of what cultural or ethnic sort, boom. The books you read, right, the authors are of this. The people you report to in your life have overwhelmingly been this color. I gotta tell you, when I picked up that damn box, I was shocked that my box, I'll say, was cappuccino, okay? It was a lot lighter than I felt comfortable about. And the whole point of the training is that if you don't make intentional decisions, then you're gonna let the tide of your experiences shape your perspective, and you're gonna miss out on a lot of people. So some training like that has huge impact.
So what I love about that example is it's a really concrete one on helping people realize their own implicit bias. And one of the pieces that you've both touched on but haven't specifically drilled down on is data. And what impact does data have, or how can prosecutorial offices use data to also address bias? I loved earlier today when Mr. McKenzie said, if you can't count it, you can't measure it, and if you can't measure it, you can't manage it. So we talked just a little bit about whether or not you've used data. Has data been put into play, and how can it be used?
We have not used data. I don't know about Carl's office. I live in the innovation hub of the country, tech, medicine, and academia. I couldn't find a piece of technology to save my life in my office to collect data. And it gets to a point where you have to start asking yourself, is this purposeful, not having this? Because if we collected the information, it'd be real bad. And I think that as leaders come into prosecutors' offices in 2018, we have 1,041 DA elections across the country, which are in the wake of the last ones that we just had, where a lot of incumbents were voted out. I think there needs to be a real conversation in the electorate from advocates and defenders about collecting data, not just for policing DAs, which is what you can do is you can't fix what you can't see. So when you present someone with information, they might change their tune a little bit, or they definitely change their tune a little bit. But also, let's talk about, like, let's measure shit that matters, that we know is making us safer, so that as a prosecutor in an office, I can be promoted for things that I'm proud about. I wasn't proud about taking people to trial and winning and getting accolades for that. Somebody's life has been ruined. What was I proud of? Kids graduating from high school. Kids getting up to a reading level that was going to help them out in life. Somebody getting a job, somebody getting housing. Things that we know make us safer in our communities. We can't measure that if we don't have the technology to do it. We're not going to have the technology to do it unless we demand it out of people. We just spent $60,000. The district attorney's office in Boston just spent $60,000 to prepare the courtroom for Aaron Hernandez's trial. $60,000. So every juror had a little TV, and there was nice televisions everywhere. I'm like, do you know what we could have done with that money to actually make our jobs better, make the ability to collect data about not Aaron Hernandez, but of the thousands and thousands and thousands of people that we come into contact with, especially in the juvenile courts. The idea being that if we stop them from reoffending, then adult court population shrinks. These are the conversations that we need to be having as we move towards 2018.
Thanks, Adam. And Attorney General Racine?
The only thing I would add to that, like you, I think historically our office really has not maintained, data in a technologically, kind of standard way. We did receive most recently a fabulous briefing at a one-day conference that your colleague at American University, Cynthia Jones, another fabulous alum of the Public Defender Service, led, where Cynthia, and maybe we can kick this information out to you all, she really asked specific questions about opportunities to collect data, like, race, gender, age, other stuff related to diversion decisions, papering decisions, sentencing recommendations, and that sort of thing. We're more than open-minded on that. We're going to do it. We now have a CIO who is in place who can build the appropriate systems. So that'll be very interesting, and indeed that'll be another check and balance, right, on not only our transparency, but eliminating or at least holding bias accountable.
And just getting rid of that we can't afford it. There's not resources. Like, we're collecting data all the time. All the time. We have this idea of collecting data means going into a file room, going through files, and inputting stuff. You have data being collected all the time about you by sending emails, by texting people. The same can be true of the criminal justice system. We just need to demand it and stop letting our elected officials waste our time and money on big time murder prosecutions where they need to get a lot of press.
Mm-hmm. If I could say one
Absolutely.
thing.
I was just going to turn to you and ask you about data, so please.
Well, there's data, and then there's, I think, political will and vision, which is so exciting what's happening here in DC. In Baltimore, when I started doing this work in '98, there were 11,000 juvenile arrests per year, and now there are 4,000. Do you think that the prosecutor's office and the system that handles these cases has shrunk by about 2/3?
No.
No. So what has shrunk? The referrals to our program, which have been documenting better outcomes at less cost, because the system needs to continue. So there's, it's frustrating to have data that shows, and recidivism is not the only way to measure the impact of this stuff. Talk to Bernard Conaway, who's, 11-year-old daughter was sexually harassed in her school and who didn't sleep a wink, a full night's sleep until he went to a community conference. And the best thing that I heard at the end of a conference was when we checked up on him, he said, "I've slept a full night ever since then." I mean, how do you, go
to that conference.
Yeah. You just said something really interesting that I think we'd be remiss to not say in this conference. Recidivism as a stat to measure the success of young people is racialized in and of itself. Yeah. Like kids in the neighborhood that I grew up never got measured by if they failed more or less. And the same way that we talk about school, like school in the community that I'm in is a way to keep kids out of prison. And when you think about where you might have grown up, nobody ever talked to you about college as the way to stay out of jail or prison. It was just like the next thing that you did after high school. And so just language and how we deal with these concepts as prosecutors is really, really important.
Well, and it brings us to really the essence of this whole conversation about what are the alternatives to keeping children out. So once the system becomes aware of a child, it's harder and harder for a child to stay out of that system. So what recommendations would you have for defenders? Let's say a child does penetrate the system and is petitioned in, but they really think this should be a child that should have been diverted. What recommendations do you have to the defender community to have conversations with prosecutors about making those alternatives happen and ways that defenders and prosecutors could work together? So Adam or Attorney General Racine?
Well, I think that in the District of Columbia, there are exceptional defenders for the most part. I would just encourage the defenders to advocate fiercely for their clients, understand what the decision makers and what the leadership at the Office of Attorney General is most interested in. And what we're most interested in is really setting up the young person to succeed in a way in which they hopefully will not be in the same position that caused the harm in the first place. So be creative in the area of restorative justice. Be creative in respect to identifying creative ways to cobble together services and experiences for young people that might get us to be creative in agreeing to a disposition with you. So fight hard and be creative as heck. I will note that just the other day, Santa Sonnenberg, our juvenile justice leader, wrote to me late at night and advocated for our office to invest in a social worker. Instead of relying lock, stock, and barrel on the social workers at the court social services, or instead of relying on the armchair social workers that we all are, right? I think Santa has made a compelling case, just by virtue of her simple 5-sentence logic, that we should have an in-house social worker who can help us make decisions not only in regards to restorative justice and diversion, but also on what the best disposition might look like for a kid.
Great, thank you.
My thing would just be watch everybody cringe in the room. Let prosecutors talk to your kids. Let them talk to your kids. Honestly, listen, you can go shake your head and say, no, I'm never going to do that. There are safeguards that we can put in place to allow prosecutors to talk to your kids. And believe it or not, the good people that are sitting right here are not looking for evidence to smoke your kid. What they're looking for is something that we can hang our hat on so we don't get smoked. And if you're going into this job thinking that your job is to defeat the enemy by doing whatever it takes, we're not going to get anywhere in this conversation. All of this is going to require us taking a step out of our comfort zone about what it is that our job is. And I guarantee you that if you let someone talk to your kid, they'll be much more likely to develop a relationship with that kid where they feel invested in that kid's best outcome. The worst thing about our criminal justice system is how devoid it is of personal communication. One thing that I train all of my prosecutors to do is be the first people to talk to the defendant's parents. Go up there and say, hello, my name is Adam, I'm the prosecutor, I know that you might have had negative interactions with our court system, with the prosecutor. But what I want to tell you is what's about to happen here today. And here's what I'm going to say, and here's why. We can agree that there's a problem, something happened in the home, and I want to do everything I can to make sure that he comes home. But what I'm going to need is for you to tell me something about how I'm going to be able to do that. Is it a program? Is it a relative? Something that I can hang my hat on. And for defenders to come and say at the first pretrial hearing date or the second pretrial hearing date, he's going to go into this program or he's going to get this job, that's not achieving what you want to achieve, because we hear it every time. If you spend more of your time with dispositional advocacy and saying, I got this program right here. This is how I'm going to be sure that from 2 to 4, 2 to 6 every single day, he's going to be jammed up. And if you bring that to a prosecutor and have that conversation about how we're working collaboratively, results will be different.
I would love to just get a sense from my prosecutor. Look at them. Okay. Those are the on-the-line prosecutors. Completely agree with you.
So I want to underscore the first thing that Adam said is we can put protections in place to make sure that this works. So on the 50th anniversary of In Re Gualt, when we're really looking at ensuring protections for children and that we empower children to have a voice in the process, the idea that they could voice how they think they can succeed in a dialogue with prosecutors is really interesting to me, but it does make me nervous. What are some ways that prosecutors can work with other stakeholders to create policies that would protect youth from being burned by having those conversations?
The reason that restorative justice works is because it's developmentally appropriate.
Right.
When you allow a young person to express themselves right after the thing has happened and tell you why it happened and their concerns and their risks and their fears, that is a much better way of going about things than saying, shut up, kid, you don't get to talk to anybody except for me, and we're just going to go through this process where you just have to keep coming back and back and back and back, and then the kid reoffends at some point in time during that period of time. Restorative justice is like the best thing going for us because it accomplishes everything that we want to have. You want to have victims feeling like they're being served? Go through restorative justice. Don't threaten them with subpoena to come in and testify, and if they don't, they might lose their kids. If you want to have some actual accountability, have someone sit in front of the victim of the crime and talk about what their action was. You try doing that with some mistake that you made. That's accountability. Going to jail at the end of some long process is not accountability. And if you want to see communities being safer, nothing makes communities safer than repairing harm. And the restorative justice community has figured out how can we make this happen without people getting burned, because people recognize the efficacy, the efficiency, and really what we're all striving for in the restorative justice community.
I love you, Ann.
Yeah. So Dr. Abramson, before we end, I just want to say to you, so what's your advice on how we can get more of these programs started? Very quickly.
I think if we all start to think of justice as healing and learning as opposed to punishment, that very different things are going to start to happen. And, it's not easy to get these programs started and to keep them going, but when people feel motivated by the idea of justice as healing and learning, then you'll go out and you'll do something that's connected to that, that's related to what Adam's talking about and what Carl's talking about, and it's about human beings. So the only thing I was going to say that, Adam said that restorative justice is developmentally appropriate. I would extend it to say that it's humanly appropriate. I come to this work as a neuroscientist because I studied how emotions affect health and illness, and I saw the incredible damage that we do to ourselves individually and socially by what do we tell people to do with their emotions? Put a lid on it.
Right.
And we suffer greatly for that. And so when we have a justice process that lets people be human, and if that excites you, then any part of doing this work, there's so many ways to bring this out. So,
can I ask one last question just to draw a fine point on this? Who can tell me who in the United States created the idea of prison? Quakers. The Quakers came up with prison because it was better than what we were doing for other people. I don't know about you guys, but there's been some technology and innovation and creativity since Quaker time. So we can like, if we go to work with an open mind about doing things differently, we can do it. Like, these rules were written hundreds of years ago.
And just to put another point on that, I want to end with Judge Hines' comment that she said the laws we've put in place really abet racism, right? Mm-hmm. So we are condoning it through the structures that we've created. Gualt celebrates putting protections in place for children, but we have to push back on the structural context that we've developed ourselves in Quaker times.
Yeah.
And really reform how we're addressing teenage behavior. And through Gualt at 50, let's reform the laws that allow children to get put in and protect them with strong right to counsel, great prosecutors, alternatives, and creativity. So thank you very much. And thank you.
Good job.
Thank you all again. Thank you, thank you. Before you all run out the door, let us just say just a couple of words by way of closing. This has been a long day and an action or information-filled day. So I want to take literally 60 seconds for you to just yell out, somebody yell out one thing that you learned today or that you were reminded of today. So somebody, I'll actually start. I was reminded how resilient young people are. By watching Devontae and seeing his positive energy and encouragement even after 8 years of incarceration falsely. Somebody else. Throw out one thing. Yes, Amanda.
Black girls are leaders, but we don't encourage their leadership. We label their assertiveness as aggressiveness.
Ooh. Yes.
Public defenders, we need to check our lives as well.
What else? Somebody throw out something.
TMI, too much
It is too much information. We got a lot more to go. Yes.
1 in 4 have criminal histories, or 1 in 4 have criminal records, 4 in 4 have criminal histories.
Wow, we are all criminals. Yeah. Yes.
Is power and policy.
Ooh, power and policy. Love it. Couple more, just 2 more. I'll let you go have a drink. Huh?
Leadership matters.
Leadership matters, absolutely. Yes.
Recidivism should not be our only measure of success.
Ooh, excellent. I can't let you go. Yes.
Acts are violent, not people.
Ooh, excellent, excellent. All right, you all, this is just the start of a conversation, and it's probably a start of a conversation that you all have had a number of times, but I hope you got some new pieces of information. I love the interdisciplinary nature of the folks in the room. We are going to go across the way again so you can have a drink and relax after this conversation. So we have a reception from 5:30 to 7, and in that reception, we are going to continue our tribute or our recognition of this 50th anniversary of In re Gualt.
So we've learned a lot today. I don't know how many of you knew that prisons came from the Quakers. The word penitentiary, of course, comes from being penitent. So what I would like to do is introduce you to another way to learn. In conjunction with the National Juvenile Defender Center, Georgetown University's library has put together what we are calling the Gualt Research Collection, which will be accessible online from all over the world. In this, and let me just say, this collection was put together by the generosity of Gerald Galt's mother and Patty Puritz, by the hard work of the NJDC staff, the hard work of the juvenile justice staff, and especially Katya Herring. I don't know if she's here. You'll probably see her across the way, our archivist. This research portal is basically a treasure trove of everything you could ever want to know or learn about the Gualt journey. In this treasure trove, we will either have on site or through access to other sites every piece of paper involved in the Gualt case, some interesting pictures, videos of Gerald and his mother giving interviews at the time he was it when he got out or when he was going in? I'm not sure, one or the other. When he got out. We have access to the papers of Chief Judge Earl Warren, Justice Fortas, who wrote the opinion. I don't know if you know, but Earl Warren wrote a note to Justice Fortas, which said, "You have just written the Magna Carta for children." We have that in the collection as well. Anything you want to know about this case, whether you're a researcher, journalist, lawyer, policymaker, you will be able to find all sorts of wonderful things in here. We also have access to other secondary sources of literature, books, articles, videos. Norman's archive is in there as well. So if you go across the street for drinks, which Chris is probably nudging me to get you there, we will have on video screens some of the material from the archive rolling. There'll be headphones if you want to listen to some of the videotapes. There will be people there handing out cards that will have the link address on it. And so with that, let me just say, I've watched this whole thing from the balcony today. I'd just like to thank myself, the planners from both organizations, the presenters, you all for coming and enjoying this conversation. Thank you very much. Let's go across the street.